Hey everyone. This is not the wildest, craziest, most out of control divorce case we have ever seen, but it is definitely the most tedious and the pettiest that I have ever shown you. So buckle up, because this is going to be a long one. This will probably be 2 to 3 days from what I've seen so far. I'll put chapters in the description for those of you who want to skip ahead, but for those of you watching the premiere, sorry about your luck. Please don't break anything. Let's do it.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Today is Tuesday, March 28th, 2023 at 1:31 p.m. This is case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Attorney Thomas Schaefer represents plaintiff and attorney Natalie Elaine, defendant.
Okay. Good afternoon to everyone, and
Good afternoon, Judge.
sorry about the events that occurred on March 7th when we were here in partial weigh-in. If, as you probably know, and I don't know how much we're able to tell you, all of our systems, computers, everything went down at that time, and so we couldn't record or do anything. So that's led us to where we are today. So, Miss Elaine, you were involved in your cross-examination of the plaintiff at that time. Ms. Tabaka, I'm going to let you know you're still under oath. So, Ms. Elaine, you can proceed.
Thank you, Your Honor, and hopefully I won't repeat too much from last time. If I stray off in that direction, please feel free to let me know. Ms. Tabaka, the provision that we are here about, which I would like to throw on the screen, it says it's disabled at the moment, but if someone could change that setting.
Just a second. Try it again, please.
Got it. All right, so we are here on whether you have violated the provision that is highlighted about Chris being able to take the children for a parenting time when you work, for short. That provision didn't necessitate anything further than your understanding and Chris's understanding that he would take care of the kids when you worked, correct?
That's not correct.
So what efforts did you make to prevent Chris from seeing the children under operation of that provision because you don't think that he was correctly complying with it?
I never made efforts to deny anything to Chris under that provision. That provision was never brought up until 2021, when the children were no longer.
It was never brought up because you guys were just operating under it as a matter of course. Isn't that true?
Right. We again had civil. We were civil. We were able to co-parent and do things unrelated to the court order.
So for 6 years, from 2015, when this entered, to the summer of 2021, the two of you had no dispute whatsoever about this provision. Isn't that true?
Correct. That provision never came up once.
And there was never a time from November of 15 to June of 2021 where you told Chris that you weren't going to permit him to care for the children while you worked. Isn't that true?
That's a very long time, but I would say I did not say that to Chris during that time period.
Was there ever a time between 2015 and 2021 where you told Chris that he didn't follow that provision correctly?
We never brought up that provision ever.
So the answer is no.
Can you ask the question again?
You blipped out, so if you repeat, please.
Certainly. There was never a time from 2015 to June 2021 where you told Chris that he wasn't following that provision correctly, correct?
Correct.
Did you ever once from 2015 to June of 2021 ask him what his plans were for the children during the time he was taking care of them while you were working?
No, it wasn't necessary. It wasn't part of what we were doing.
Right, exactly. And you didn't require him to tell you what his plans were with the children, correct?
Well, again, you're talking about the provision, which we were not operating under.
Did you ever express to Chris that when Daniel transitioned from daycare to preschool or preschool to school, that this provision was no longer operable?
Oh, I believe I answered that last time, but we never brought up this provision ever until 2021.
Did you ever express that this was only a temporary order and it was no longer operable?
We never discussed pretty much anything in this court order until 2021, aside from the holiday schedule.
And you discussed it in 2021 because you stopped following it and Chris asked you to continue following it, correct?
Please ask the question again.
And you discussed the order. You keep saying you never discussed it until 2021. You started discussing this provision in 2021 because you stopped following it and Chris wanted you to continue following it. Isn't that true?
Sorry, ma'am, no, he was the first person to bring up this provision after the actions that he took against me when I said, I'm going to be with my children during all my parenting time, which I said at the last hearing was for our wellness due to the nature of the uncomfortable abuse and harassment going on at that time to avoid unnecessary.
Ms. Tabaka, if you weren't following this provision and mentioning this provision and no one even cared about this provision, then why would you tell him that you're no longer going to allow him to have time with the children while you worked?
I never said those words, ma'am.
What did you say?
I said that I will be exercising my parenting time with the children.
Why did you say that if there wasn't something different occurring?
Because your client specifically kept referring to that provision.
And how did he do that?
Over the OFW platform.
Wasn't it you who first made the announcement that you would from henceforth start exercising all of, quote, your parenting time under the order?
I believe I would be the only person that could say that, but as far as
Other than, no, you said that you were responding to him bringing it up, but you brought it up first. Did you not?
it was probably an answer to a question when he asked about getting the children early on a Friday, stating he's going to work at Binder Park, or excuse me, John Ball Zoo, and would like the children early. And I said something to the effect of, don't worry, that's okay. I'm going to be taking the children on my parenting day, and so far moving forward on all of my parenting days and times.
But why would you have to say that if you weren't following this provision that said when you are working and it's your parenting time, he can parent the children? Why would you have to make that statement that from now on, I'm going to have them on that time?
So my statement had absolutely nothing to do with that provision. That was just a general statement that for my welfare, given the circumstances of harassment from my ex, to avoid unnecessary contact with him moving forward until there's some sort of healthy resolve.
And you didn't file any motion in this court up until recently to declare this provision no longer operable, right?
I didn't file a motion regarding this provision specifically at all.
Well, you did. Just a few months ago, you filed a motion to eliminate the provision, claiming that it was only temporary, it was only supposed to be operable while the children were in preschool and so forth. You don't remember that?
Actually, madam, I asked for a motion for change of parenting time so that we could establish a more healthy, effective parenting order so that these issues are no longer an issue as it is affecting everyone's lives, including the children. That is why I filed a motion for the parenting time, not the provision, ma'am.
So you deny that your motion asks the court to remove that provision on several bases. A, because it was a temporary order. B, because it was only supposed to be operable when the children were in preschool. You deny that?
Well, without reading the motion directly to you, the motion was again meant to fix the parenting time situation, which was written in 2015 when the children were in daycare and preschool, and all of those things are no longer applicable. There's completely different life circumstances and schedules, and we were able to work around that all these years without a change because we worked together. Now
you were able to work around it because you worked together until Chris filed an ex parte motion about your boyfriend, correct?
That's a repeat question from last week, but no, ma'am, there were multiple things that Christopher Tabaka did leading up to that, multiple calls to CPS that were unfounded.
Ma'am, I would move to strike. I would move to strike her
Could
testimony.
Could she have an opportunity to answer before she gets cut off?
Well, if she answers the question directly and doesn't go off on a narrative, please.
And I would move to strike any testimony about based on facts, not in evidence, about who called CPS at any point in time.
No, I object to that, Your Honor. It was a proper answer to the question.
Well, I don't know how she could have answered and knows who called CPS, as it's not something that gets disclosed, and so I don't know how she would have information about that.
Well, we can go into that, Your Honor. There is a basis for that.
Okay, well, maybe we'll have to at some point, but not on regard to this question. So court will strike that answer. Please move on.
Thank you. We established last time, Ms. Tabaka, that you were very upset when Chris filed the ex parte motion regarding Kyle Gallus, correct?
You can use the word upset. I was taken aback. I had no idea at all when I received that in the parking lot of Menards, what was going on.
And the order that the court issued in response to that motion was issued on May 28th, 2021. Do you recall that?
Approximately.
And then you filed.
I guess I'm going to object this line of question. This beyond the issue before the court on the contempt petition. We've got a couple other things that are pending, such as custody and support and whatever, but I think this is going beyond what this motion is about.
Okay, Ms. Elaine, what's your response?
Your Honor, I'm doing a direct tie-in with the timing of the issuance of that order and her ceasing to abide by the provision in the judgment on which we are here.
I'll give you a little leeway, but please focus on what we're here for today.
Absolutely. Absolutely. So that order, you agree, entered approximately May 28th, 21, correct?
Yes, approximately.
And you filed a motion to vacate that order, did you not?
I had an attorney file a motion. It was a very long time ago. I don't remember specifically what that motion said.
All right. You went to court. Do you remember going to court and asking the judge to vacate that order and the judge denying that motion?
I remember going to court. Yes.
All right. The docket will reflect, and I would ask the court to take judicial notice that occurred on June 14th, 2021. And then Ms. Tabaka, on June 15th, 2021, did you send the following Our Family Wizard message to Mr. Tabaka? One second, I can make that a little better to see.
Okay, I can see it. So what was your question regarding this email?
Just acknowledging that you wrote this Our Family Wizard message to Chris on 6/15/21.
This was a response to a message that he sent, so the entire message is not there, but yes.
What did he say?
He said, "Good morning. I am working at John Ball Zoo Friday. I need to get on the road earlier than the recent 9 a.m. drop-offs. Kids will enjoy being behind the scenes with the animals. I can meet you in Battle Creek somewhere, it's on the way, or at Denny's, but need to meet at 8 a.m. to get there and back in time. So he said that he was working that day.
But it sounds like he said he was going to take the kids with him. Right?
But he also said that he is working that day.
Okay, just answer my question. He said he wanted to take the kids with him, correct?
That would not be the language in his statement. No, implied, sure.
Okay, implied. He's implying that he's going to take the children with him. And do you have any explanation for why he would have been assuming? Were you working that day? You were supposed to work that day, scheduled to work?
My answer is on the email exhibit that you have on the screen.
Right. I understand you said you were off, but being off work means generally that you had been slated to work at some time, but that you're taking the day off. Am I accurate?
This was well over a year ago. So going by the email, I'm off Friday and plan to keep the kids with me. It was my parenting day.
It was your parenting day if you weren't working, right? But if you were working, it should have been Chris's time. Isn't that why he wrote you and said, here's the change in pickup time I need to have executed because of the zoo thing?
His email was regarding changing a pickup time so that he could get to work at a specific time.
Okay, so he was assuming that you were working and assuming that, like always, he'd have the children while you were working, correct?
Your Honor, I'm going to object to the form of the question. She's referencing what her client was assuming, and there's been nothing in the record as to what his intent was. And certainly my client doesn't know what the other side is assuming.
Okay, Ms. Elaine?
Well, I would say that the exchange is suggestive of exactly what I'm saying, and she can, if she knows something different, she can certainly say. But if he's just writing her an email saying, hey, I need to change the exchange time on your workday from 7 to 8 or whatever it was, that he's assuming he's gonna pick the kids up if she has a different expectation.
Maybe rather than ask if what someone was assuming, we could maybe ask what their plans were, or had they discussed it previously, or something of that nature.
All right. Had you had any discussions prior to this exchange about that particular Friday and whether Mr. Tobacco was going to have the children?
Not that I'm aware of.
All right. So in any event, you tell him in response to his notice to you that he needed to change the pickup time that you were going to be off that Friday and you would plan to keep the children, correct?
I'm sorry, could you repeat your question?
Yes. In response to his notification to you that he needed to change his usual pickup time for the children, you responded that essentially you didn't need him to pick them up because you were going to be off work.
Correct. My response is you should be clear all for Friday because I'm going to spend the day with the kids. Yes.
Right. You told him you're off work. No need to pick them up. I'm off work. Right. That's the implication of that language, right?
Actually, it's right there in black and white, exactly what I wrote.
I would move for the admission. I don't know that that was settled, the admission of B.
Okay.
No,
Mr.
no
Schaefer,
objection. No objection.
okay, defendant's exhibit B will be admitted, there being no objection.
Thank you. And then just to tie up that loose end, those timesheets that we went over last time, I would ask that I proposed as A, I would ask that those be admitted as well.
Okay, Mr. Schaefer, what's your response on those?
I don't think the proper foundation has been laid on those, Your Honor, and I don't know at this moment they never got identified as to how many sheets there were or where they came from or any proper foundation. So I don't think the proper foundation.
Well, Ms. Lane, maybe you can ask a few more questions and we can proceed with that.
I will. I do recall asking her all about how those timesheets get generated last time, and she acknowledged the process and then how she signs them after they're reviewed and how they're entered, and she acknowledged that these were her timesheets. I don't know if you'd like me to do more than that, I can certainly try.
Well, if maybe ask her if those represent the entire period of time and identify how many pages. So I don't have anything
Okay.
written down here as to the amount of pages.
Okay. Ms. Tabak, I'm showing you a document that's a PDF of 57 pages, and they go through March 12 of 2021 to 11/3 of 2022. You were provided these well in advance of our first hearing, 10 days, as a matter of fact, in advance of our first hearing. And attached to the records that you were provided was the certification from your place of employment as to the authentication of those documents as business records. Do you acknowledge that these are your timesheets?
First of all, how many pages are there?
57.
57? I don't recall you going through all 57. Some of the are not signed, and specifically, I don't think the proper foundation of 902 has been met. Specifically, 11C has not been met. That we were given notification that these were going to be entered under 902 as self-authenticating.
Well, she can still identify those if she's able to do so.
Okay, well, specifically the one that is up there now, and I don't know what it is. There's no signatures on it. There's no particular date, so I don't know what that means as an exhibit.
Well, as these were records given to me by the county, so I don't know that it needs her signature. If they were given to me by the county pursuant to a subpoena that's attested to here by the signature of their counsel. So whether she signed them or not, I don't think has anything to do with whether the records are authentic. I would also say that I'm not trying to self-authenticate them. 902 does not apply. The business records hearsay exception applies, and all that is required there is that I have this certification, which I do. And
I don't think that's accurate, Your Honor. If she has the keeper of the records here under the prior court rule, fine to authenticate it, but you can't have a document authenticating another document without the person there. The self-authentication is the only way that would get in, but there's another requirement to that she has not complied with.
Well, we'll go to 902 parens 11 states the original or a duplicate of a record, whether domestic or foreign, or regularly conducted business activities that would be admissible under Rule 8036 if accompanied by a written declaration under oath by its custodian or other qualified certifying person, I'm sorry. And apparently we do have that certification, so why
Your
would
Honor, if I may direct the court's attention to the rest of that court rule. The rest of the court rule 11 after 11C says a party intending to offer a record into evidence under this paragraph must provide written notice of that intention to the adverse parties and must make the record and declaration available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge them. I am submitting we never received an indication from opposing party that they're going to offer it under that particular court rule of 902.
Well, Mr. Schaefer, I'm looking at the certification. It says under Michigan Rule of Evidence 902 parens 11, and Ms. Elaine had clarified to your client that it had been provided to your office, and she had seen it approximately 10 days prior to the last hearing. So I guess I'm in a quandary.
Okay, well, if Your Honor reads the 11 A, B, and C, and the other paragraph, there are two steps to this. Number one, the certification is under the prior court rule of 800 series, but there's one more requirement. The other requirement is that I must be notified by counsel saying I am going to present this under 902. Because if in fact it's not given, then I think it's fair to assume that there's going to be a records keeper there who will verify what the records are.
Ms.
Your
Elaine,
Honor, I'm sorry, that seems to be a way overly technical interpretation of the rule that, quite frankly, is the first time I've ever heard it proffered. I sent the
Well-
exhibits as exhibits that I intended to admit. I'm really not sure what else Mr. Schaefer really needed as advance notice that these were exhibits I was intending to admit.
Well, Your Honor, the court rule is pretty clear and it has a must in it. And to me, a must means a requirement. A party intending to offer this under this paragraph must provide written notice of that intention. That has never been done. I think she certainly has a right to attempt to get it under the 800 series by having the records keeper here to verify the three provisions therein, but she did not comply with 902, and that's what she's offering it under. It's not a technicality, it is a requirement of the court rule as an exception to the hearsay.
okay. Well, what the court's going to do in this matter, the court does note, again, as stated, that under 902, parens 11, it states the party intending to offer a record into evidence of this rule must provide written notice of the intention to the adverse party, must make the record and the declaration available for inspection sufficiently in advance of their offer into evidence to provide the adverse party with a fair opportunity to challenge them. Clearly, as stated, she disclosed those documents as exhibits. Again, the certification is under 902 parens 11. The court is going to admit plaintiffs or defendants exhibit A in this matter. I do believe she has complied with 902.
For clarification, that's 57 pages, Your Honor.
Correct. Yes.
Thank you.
Go ahead, Mr. Lane.
Thank you so much. Ms. Tabaka, you indicated in your Our Family Wizard message that you would be off on Friday, June 18th of 2021, when Mr. Tabaka asked for that pickup time change. And just one moment here. I'm showing you your timesheet as of for June 18th, 2021, that Friday. And in fact, you indicate on here that you worked 4 of the hours of the 8 of your scheduled day. Isn't that correct?
Yes, and I have notes attached to all of my time cards. That's what those second unsigned sheets are. And so on that specific date, yes.
Are you saying in this exhibit, in my exhibit?
I guess we're a moving target here, and can that be enlarged? It's difficult to see at best.
I can try. I can. Yeah, I can move it like that, and I can do it like that. Is that better?
Well, it's obviously larger.
All right. My question to you, Ms. Tabaka, is did you in fact take work 4 hours on the date of June 18th, 2021?
Is that what my time card says then? June 18th.
Did you say if that's what your time card says, then yes?
If we could have one moment, Your Honor, to locate this document. It's pretty hard to see on the screen.
Okay, go ahead.
I think this is the one that she has up. Yeah, I think you
Don't.
Yep, for 4 hours that day, my children were with their grandparents in Holland. They had tickets to an event at the Spark Lab Museum in
Yeah.
Holland. And during that
That's not
time,
my question. Ma'am, that's not my question. My question is, did you work for 4 hours on June 18th?
yes, I worked for 4 hours on June
Thank
18th.
you. All right. And then the next time that, so back to this really quickly. You had this email or our family wizard message to Mr. Tabaka on the 15th saying you're off on Friday and plan to keep the kids with me from Thursday at 7 till exchange on Father's Day, the day after your motion to set aside the no contact order was denied. The next mention of you declaring that you are no longer going to follow the judgment occurred on June 23rd, 2021. Isn't that correct? And
I'm going to
showing that.
object. I'm going to object to the form of the question, Your Honor. It has about 5 different questions within a question. It's a multiple question.
Well, Ms. Owen, you can break it down. We don't want a compound question.
I can, thank you. Ms. Tabaka, let me try it this way. On June 23rd, 2021, did you send this Our Family Wizard message to Mr. Tabaka?
What was the date, ma'am?
6/23 of 21.
Again, can that be enlarged, Your Honor? And is that an exhibit? What number is that?
I would offer this as an Exhibit C.
Okay.
I don't find an exhibit C that was provided to us, Your Honor.
It's titled OFW. I will be using all my PT 6/23/21.
Correct. I have a number of dates. I have a 6/28. I don't have a 6/23, Your Honor. Oh, excuse me, a second. I think I have located. They were mixed up. Hang on. Here's the 6.
Okay, I see it. Now, what was your question again? I'm sorry.
Just asking if you sent this.
Yes, I sent this.
All right. And to the best of your knowledge, was this in response to anything or did you initiate this conversation?
Well, subject line says reply, so it must have been reply to something that Chris had said.
Right, but do you recall anything that he said?
I would have to open my family wizard because it's not part of the exhibit.
All right. And what you told him in this is, as I have been since court on the 14th of June, I'll be using this platform to communicate like the judge ordered. I will also be utilizing all in capital letters, my parenting time as is in the original order signed by Judge Miller in 2015 from this moment forward, so that there is no confusion or concerns of last minute changes. Do you recall sending that?
Yes.
And that was the moment in time, was it not, that you declared that you would no longer allow Chris to take care of the children while you worked, right?
Did not say that in that email.
Well, why don't you tell the court what you were saying in that email then?
I was saying that I plan on exercising all of my granted parenting time from the 2015 order.
Why would you need to say that if you had always been exercising all of your parenting time as in the original order?
Again, this is one I've answered many times, but again, change of circumstance. Again, we were able to get along for many years, and then a series of events brought on part by the defendant changed all of that. And that's why there is this change.
All right. I'm now showing you an exchange between you and Chris dated 6/28/21, and I would move actually first for the admission of proposed C, the 6/23/21, our
Okay.
family was.
Okay, Mr. Schaefer,
No objection to C, Your Honor.
defendant's exhibit C is admitted.
Thank you. Moving on to proposed D, of our family wizard exchange from 6/28/21. I would also offer that. Ms. Tabaka, do you recognize this exchange.
6/28/21, is that correct? We're talking about both communications. What specifically was your question on this?
Just if you recall this exchange.
Your Honor, we cannot, I see half of what is up on the screen. And do we have a number of it, this exhibit?
This is proffered as D.
Is it C?
D. D is in dog.
Okay, very good. And again, what has been brought up on the screen is half of what was presented prior. So I need to know if it's the whole thing. And I see the whole exhibit.
It's the whole thing. I can only show so much at one time, but it's a 2-page exhibit.
A 2-page exhibit.
Well, the second page just says, thanks, Chris. It ran over to the second page. So most of it's on the first page, but there are 2 messages on the page.
Okay, I've got it. Sorry, can you clarify your question again, please?
Just if you recall this.
I recall this communication.
All right. And you see that in the message from you, from Chris to you on June 28th of 21, he says the following: with an almost 6-year history of taking care of the kids while you are working and with it written into our custody agreement, please consider this advisement in advance that I have plans and look forward to continue to exercise my parenting time while you are working. And then you responded to that, correct?
Yes, I have a response about that.
You said also, as I stated in a prior communication, I will be exercising all of my court order parenting time now that my job allows it. So tomorrow morning at 9 a.m., I will be picking Daniel up at Denny's and will be returning him to you at 9 a.m. on Wednesday. So on and so forth, of course, for all my days written into the 2015 order signed by Judge Miller. And again, Ms. Tabaka, you wrote that because you were changing in a massive way what had been the status quo for the children after Chris got that ex parte order, correct?
No.
I've moved for the admission of D.
Okay.
I have no objection to D, Your Honor.
Defendant's exhibit D is admitted.
Thank you. And when you made this C change for the children, where they stopped seeing their father before and after school almost every single day of the school year and all summers long, that had a negative effect on the children's psychology, did it not?
You're asking me an opinion, but if you want my opinion on that, ma'am, I spoke with my children and they felt much more comfortable.
I don't want you to tell the court what the children said.
You asked for an opinion.
Your Honor, I think you're trying to answer the question. Otherwise, I would object to the form of the questions. Ask for an opinion.
Well, Ms. Elaine, you can't have it both ways. If you're going to ask if that had an impact, she has a right to answer it, or don't ask the question.
Well, I think she could answer from her observation without saying what the children said. And that's really what I'm asking. I can clarify.
Well, maybe she can. Maybe she can't. I don't know.
Okay. Ms. Tabaka, if you can, did you make personal observations that this change that you unilaterally made on the family had a negative effect on your children?
Your Honor, again, I'm going to object to the form of the question. It's an opinion on her part as to a unilateral decision, and it's a compound question again. So it's like, have you stopped beating your wife yet? You can't answer the question.
Well, if she can answer, if she observed anything that had a negative impact upon the children, if she didn't, so say she didn't.
I don't quarrel with that question, but that wasn't the question. It is prefaced by a unilateral decision to do something that didn't have effect on the children.
Okay.
That is a compound question.
Okay, go ahead, Miss Elaine, re-ask it.
All right. Did you personally observe a negative effect on your children after this change?
No, ma'am.
Did you ever report to anyone that you observed a negative effect on your children after this change?
Did I ever report to anyone that I felt there was a negative impact on the children to the change? No.
Yes. Okay. Did your children have an intake of which you were a part to Comforts of Home Counseling?
I'm sorry, I don't understand your question.
Do you recall your children being seen by an outfit called Comforts of Home Counseling?
Yes, yes, I do. They continue to go to counseling there.
And did the counseling facility conduct an intake with you, asking you questions about why your children were being needed to be seen?
They did, yes.
And were you asked why? So I assume then you were asked why the children needed to be seen, and you provided an answer as to what you thought, correct?
I provided them documentation and what was going on.
Did you provide a verbal answer to them as to what you thought the issues were?
It's likely if they asked me a question that I gave them a verbal answer, yes.
All right. I'm putting on the screen records I obtained from the counselor as impeachment evidence, and I'd like the witness to answer whether she remembers having an intake with Susan Counsel about Daniel on 2/24/22.
Okay. What was your question again, please?
Do you recall having this intake about Daniel with Suzanne Counsel from Comforts of Home Counseling on approximately February 24th, 2022?
Your Honor, again, I am not sure that's a proper question with the exhibit. If the exhibit's going to be attempted to be offered, I think it has to speak for itself, and counsel is identifying this as something that I don't see in the document itself.
Well,
I mean, this isn't.
I think she can ask her. She can ask her the question whether she admits the exhibit or not.
Your Honor, I would say that this was over a year ago, but I would say that this is something that Chris did, this particular intake. I went in separately afterwards to speak with them.
All right, but you do recall having a conversation with Suzanne Counsel?
I went into the facility personally to provide documentation.
Okay, so my question was, you do recall having a conversation with Suzanne Counsel?
Madam, that name and the date, I cannot say. I can't answer that honestly. I don't remember.
All right. So Ms. Counsel has in her notes that Alexis states Daniel is dealing with some family issues. He's having
Your Honor, I'm going to object the counsel reading from a document, not into evidence. It's not proper at this point in time.
Okay, Ms. Elaine?
Your Honor, it's impeachment evidence. She testified that her children were not having a negative psychological effect from the change in parenting time, and that she had never represented to anyone that they had, and these notes demonstrate otherwise.
Well, and that may be, we could ask her the question, but I'm not going to let you read from the document. The document is not into evidence, nor does it in fact satisfy any of the exceptions to hearsay.
It's a statement against interest.
Well, you haven't identified that she made the statement, so the document doesn't identify who made the statement.
And it says Alexis made the statement.
Oh, I guess
The proper foundation isn't laid for the exhibit, and the proper foundation isn't laid for admission against interest or anything of that sort.
Well, I don't believe, respectfully, and I can check the rules, but I don't believe that impeachment evidence needs to be admitted. It's just shown to the witness, and the witness is impeached by it if the court believes that the witness lied.
Well, there's a proper procedure of that sort of matter, and the proper question hasn't been asked of my client.
well, if you can lay a better foundation, Miss Elaine, go ahead and do so. But I'm just not impressed with the again at this point. I know it says Alexis states, but without that, I don't know. Did she state that or not, or is it? I don't
Well,
have
if
substantial reliability on this.
I guess if the court will permit me to ask her that, and then the court
Okay.
can weigh. Yeah.
Okay, go ahead.
So the counselor writes in her notes, Alexis, that you said that Daniel is dealing with some family issues.
Excuse me, Your Honor, I object to that. She can't be saying what somebody else said. The proper question is, did she say it? And
I'm going to ask her if she said that.
I think that's what she said. She was saying she was asking her if she said that.
No, she said the document says.
Okay.
this.
Well, change your question, Ms. Elaine.
Okay. Did you say Daniel is dealing with some family issues? He is having some anger outbursts, and we want him to have some tools to be able to cope with all of the changes he has experienced. There was a fairly consistent lifestyle pattern for about 6 or 7 years. And about a year ago, things happened between us, and it was a very abrupt and significant change. Essentially, their overnights remained the same, but for 7 years, their father and I managed our own schedules as far as morning and afternoons, and one worked well for us. But now we are strictly following the court order. Did you say that to the counselor?
Just a minute, Your Honor. If that's going to be the question from this, let's give the whole statement.
I don't know that I have to say, there's a bunch of things in this document that are attributed to her. I just want to know if she said that.
Well, I don't think that she has to put the whole statement in. Mr. Schaefer, you have a right to go into that again on direct if you wish to do so.
You want me to go ahead and answer that question, Your Honor?
Yes, go ahead, ma'am. Answer the question.
Yes, I do believe I said that to an employee there at Comprehensive Home Counseling.
Thank you. You continued to work full-time from prior to June 2021 to current, correct?
I've always worked full-time, ma'am.
In the exhibits that your counsel provided to my office, you have a chart that I believe is supposed to be in response to the chart Mr. Tabaka prepared to show all the missed parenting time. And I'm just going to show you this really quick. Your Honor, my intention is not to have this admitted, but just to ask her a few questions about it. I assume since they provided it to me as their proposed exhibit, they will do that part.
Okay.
But I just want to ask her a couple questions.
Okay, go ahead.
So the top of this, ma'am, says Alexis responses to defendant's tabulation sheet, claims of denied parenting time, right? Get to the top here. That look
Yes.
familiar?
Yes, ma'am.
And while a lot of it from my end is fairly illegible, I do notice over here in this far right column that you have what seems to be explanations or rebuttal to his claim of missed parenting time. Is that an accurate assessment of what that column is?
That column is for notes and also to acknowledge if he provided me notice and plans. That's what that column is for.
So essentially for every line item that Mr. Tabaka has identified as missed time because of your violation, your response is he did not give advance notice or provide any plans for this particular date. And you just repeat that throughout the document, correct? Defendant did not give advance notice or provide any plans for this date. Defendant did not get, is that your defense?
I went through each and every date specifically to verify that information on every single one of those.
Right, but your defense to all of them is defendant did not give advance notice or provide any plans for that particular date, right?
That is what the notation in the 2015 order specifically states, ma'am, yes.
And do you not consider, for instance, I'm showing exhibit D. Do you not consider Mr. Tabaka saying, I have plans to and look forward to continuing to exercise my parenting time while you're working? Do you not consider that notice?
No, I do not consider the notice to specific dates.
And just to reiterate, I think something we already went over, Mr. Tabaka never once in 6 years wrote you, emailed you, texted you, called you the night before and said, hey, tomorrow I intend to take care of the kids while you work, right?
Correct, ma'am. 6 years, we had a civil arrangement. It never came up. It was never an issue.
All right. I have no further questions for this witness.
Okay, Mr. Schaefer, do you wish to do your direct at this time or reserve on that?
I think I'll reserve, Your Honor. Thank you.
Okay. Okay, Miss Elaine, next witness.
Call Christopher Tabaka, please.
Okay, Mr. Tabaka, we'll have you raise your right hand, be sworn in, then we'll proceed.
Okay. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Thank you. Mr. Tabaka, we're here because of the, you're marching again.
Yeah.
All right. We're here because of the November 3rd, 2015 order that closed your custody case between you and Alexis, correct?
Yes.
Do you know why the video is doing that or?
No, but I'm thinking I need to switch computers. I don't know what is going on here.
All right. Your Honor, may we
Well,
have-
if he's able to be heard, I don't care that it's jumping, Miss Elaine, as
I'm fine with it.
long as we can hear him.
Okay. All right. It may start to bug me. I guess you could, can you turn, there we go. Can he turn his video off and leave it off, or does the court prefer he be seen?
No, that's fine.
All right, Chris, just leave it off for now.
Your Honor, I guess I would have him on video if in fact he's going to do this by Zoom. I think we're entitled to have a view of him as to what he's looking at, who's there and all that sort of stuff.
Okay. Well, then, Mr. Tabaka, you're gonna have to go to another computer then if Mr. Schaefer wants to see you.
I will do that immediately, Your Honor. It'll take me about two minutes.
Okay,
I think we're back in business.
okay, good.
Can you hear me?
Yes,
May I proceed, Your Honor?
yes, go ahead.
Mr. Tabaka, we're here because of the November 3rd, 2015 order that finalized your custody case, correct?
Correct.
And on that date, November 3rd, 2015, do you remember why you were in court?
We were in court due to a temporary motion to alter parenting time, if I recall correctly, was how it started.
And then how did it end?
It ended with, rather than a temporary motion, that ended in a permanent court order.
The two of you, meaning Alexis and you, I'm assuming with your attorneys, negotiated a final order?
Correct. We negotiated a final order without going in front of Judge Miller. We negotiated it in another room nearby. I don't know what that's called.
All right. And the result, hang on, of that is one of the provisions is why we're here today. So I will show that again. At issue is this provision that's highlighted, correct? That you can take the children for parenting time and the younger minor shall for morning parenting time, and both children on Fridays during such time as plaintiff is working, so long as plaintiff is advised of defendant's plans in advance, right?
Yes.
Excuse me. Very good. Withdraw the request.
Okay.
And that appeared again under the week 2 so that it was consistent as between the 2 weeks.
Correct. Mhm.
Was it your understanding, Mr. Tabaka, at the time that this was a temporary provision?
No, not at all.
Were
It was
there
a
any,
It was a permanent court order, so.
were there any discussions about this being a temporary stopgap for a certain amount of time for the children?
No.
Was it your understanding, or was there any discussion that this would end when the children reached a certain age, grade, etc.?
Nope, it was a permanent court order.
Right, but the intent behind it, was it intended to end
No,
at any point in time?
No.
And in fact, who was in school and preschool, if anyone, in 2015 as between Maddie and Daniel?
In 2015, Madeline was in a preschool in Jackson. After the court order, she was moved to a preschool in Marshall, Michigan. Daniel at that time was before preschool. He was still very little.
And when did implementation of this provision begin?
If I recall correctly, as soon as we had the agreement in place, Maddie started going to preschool and we started following the court order.
And tell us what that looked like as far as following the court order.
Following the court order during that time, if Alexis was at work, I would take care of the kids. On days that she had the kids, on days that she was scheduled to have the kids, I would meet her at 4:30 after she was done with work at the Denny's in Marshall, which is our prescribed meeting place. And I'd give her the kids then.
And how often would you take advantage of that provision? In other words, how often would you care for your children while she worked?
100% of the time. The only exceptions being one vacation every year in Pittsburgh, and the very rare occasion that I had an emergency at the zoo, I'd be doing relief work at.
Did you email or text or call Alexis every day and tell her that, hey, the next day I would like the children while you work?
Not at all. We had a schedule. I met her at 8:30 at Denny's, got the kids, and dropped off at 4:30 if that was her time, according to the court order.
Did Alexis ever say to you at any point during from 15 to 2021, hey, this is only a temporary order, we need to stop going by this now?
Your Honor, I'm going to object. There's a lot of leading questions here. This is her witness, so I would respectfully ask that they not be leading.
Okay, well, okay, Ms. Elaine, I guess reformulate your question.
All right. Did Alexis ever complain at any point in time that you shouldn't be following this provision anymore up until she did so in 2021?
No.
Again, Your Honor, I'm going to object to the leading question. It's a compound question.
I mean, it's a yes or no question.
It is. It's a tag on at until it stopped in 21.
Okay, well, break the question up so it's not compound and.
All right. I'm not sure what was compound, but I'll try again.
Well, you said if basically if she had ever complained about that until that particular date. So
Right.
ask her prior to that date if she'd ever complained about it, and then ask after that date, should she ever complain about it?
Prior to June of 2021, did Alexis ever complain about that provision being inoperable?
No, everything went according to, it was clockwork. Everything was smooth as can be.
Prior to 2021, did she ever tell you that you weren't exercising it properly?
No, not until June of 21.
Prior to June of 2021, did she ever tell you that you weren't complying with the strictures of the provision?
No.
What year did Daniel end preschool?
Daniel was in preschool 16 and 17 and 17 and 18. So he finished in 18.
And then I take it from your testimony thus far, after he got out of preschool, Madeline was already in first grade at that point, right?
Madeline was in first grade in 2018. Yes.
That you continued to take care of the children while Alexis worked from 2018, 19, 20, and up through until June of 2021.
I'm going to object to the leading question. That's totally a leading question.
Okay, reformulate your question, Miss Elaine.
Did you continue to take care of the children after they ended preschool?
I did. The only difference then was rather than driving Daniel and Madeline around to the preschools, I had bought a house 2 blocks away from the elementary school so I could walk the kids to and from the elementary school each and every day.
When Alexis began refusing to comply with the provision in June of 2021, did she ever tell you that she was doing so because that provision was only meant to be temporary?
Objection, leading question. She's suggesting the answer, Your Honor. As to the date.
Ms. Elaine, what's your response?
I just don't see these as leading, Your Honor. I'm asking him yes or no questions.
What? I said yes or no, but it's suggesting the answer that it was stopped in June of 21.
She already
That is
admitted,
not
she
an answer.
testified she stopped it in June
She
of
did
21.
not.
Yeah, she
Did
said
not.
that.
That was
you
the
instituted
suggested
that day.
answer.
I didn't hear you. I didn't hear you, Mr. Schaefer.
That was the suggested answer in her question to my client, but that was not the answer, and it is suggesting the answer to her client.
I think her testimony was, quote, a major change. She instituted that major change in June of 2021. And she gave all the reasons because of harassment and
Well,
she didn't want to see him.
I think you can reformulate it because she didn't state what the change was, only that there was a major change. So ask him, identify what the change was and go from there.
When did this all change, Mr. Tabaka? What you had been doing as a matter of daily routine from November 2015 on? When did that change?
It all changed in the middle of June 2021.
And how were you informed that a change, or how did you come to know about a change?
Through OFW. I can't remember the exact date, but she said she was going to exercise all of her court-ordered parenting time. She had already said that she was going to have the kids, or she wasn't going to work and she was working. So it all took place in the middle of June.
And I think as we established through Ms. Tabaka, that all corresponded to the time that you asked the court for an ex parte order involving Kyle Gallus, her boyfriend, correct?
Again, Your Honor, leading question.
Well, I do believe it suggests the answer, so I'll sustain it to ask him if he knows.
Mr. Tabaka, was there anything going on between you and Alexis that you believe caused her to change the way this provision was going to be honored?
Absolutely. On May 28th, there was an ex parte order by Judge Kirkham involving Kyle Gallus, her live-in boyfriend, due to something that he had done to my son. On 6/14, she tried to get that overturned. 6/14/21, she tried to get that overturned. It was rejected. And then the messages started on 6/15, 6/18. All the changes took place immediately thereafter.
And since June of 2021, to the best of your knowledge, has she ever allowed you to care for the children while she worked?
I have asked repeatedly, and not a single hour, not one.
You testified a moment ago that the operation of this agreement was clockwork, right?
Mhm.
So did you ever alert her to what your plans with the children would be? Like what you were actually going to do with them during your parenting time?
I'd say 95% of the time I didn't inform her. Like 98% of the time, occasionally I'd fill her in because she's the mother of the kids. So if it was something of interest to her or something that was interesting to the kids that I'm sure they'd want to share with her, I'd tell her what my plans were. But other than that, no.
So because of the way your parenting time worked and then this provision worked, did you take the children to school every single day?
I did.
Did you pick them up from school every single day?
I did. And again, there are 1 or 2 exceptions. First day of school, she'd always be there for the first day of school. And then there'd be 1 or 2 other days during the year that she might be there for pickup. But yes.
If a child was sick and she was working, who cared for the child?
I cared for the child. It was understood that I would do so, and I happily did so.
If the children had a day off from school, who cared for the children while she was working?
Again, that was me. Marshall, about 5-6 years ago, started doing a lot of half days. So we have a lot of odd schedules. I would take care of the children during those times.
What about if there were snow days and she worked, who would take care of the children?
Again, I would take care of the kids.
And when the pandemic began, did your children have to do remote schooling?
Yes, Marshall had the kids out of school for several months. I had them here. I basically did at-home schooling with the children. And then Marshall went to a hybrid in terms of some remote work with the teachers. And again, the children did that all here. Well, Alexis was at work.
Do you recall one day of remote schooling that your children had due to the pandemic that Alexis oversaw?
I don't recall any during the pandemic, no.
If you had to estimate, Mr. Tabaka, how many weekdays per year did Alexis have the children between November 2015 until June of 2021? So school days.
Right. We were splitting, so probably spring break, half of spring break, half of winter break, typically a week or so in the summer each. That was pretty much it in terms of weekdays when she was working.
Now, logistically, there is a distance between the two of you, correct? So there's a commute?
Yes.
And did you testify she would bring the children to your area?
Almost all the time she'd bring them and we'd meet at Denny's. Occasionally, if I was in the area in Battle Creek, I'd drop her a note and say, hey, I'm in the area. I can save you a trip and pick up the kids. But it was almost always at the Denny's in Marshall. She did drop them off at the house off and on before 2021 as well. If she was running late or something, she'd just bring them by the house.
So she would bring them to you before the start of school?
Yes.
And then what would you do with the children up until their school start time?
Make sure they had everything together. I mean, during winters, get the gloves together, the hats together, the snow pants, all your the boots. Otherwise, the kids get restricted to blacktop. Make sure their lunches were together. I put notes in their lunches every single day. I have since they were in kindergarten. So I'd have those for them, put them in.
Like personal notes to your kids?
Mm-hmm.
Aw.
Yeah, I have hundreds of them.
And how about their backpacks? Did you manage making sure they had their schoolwork together?
Yes.
And did you make lunch or did you send money with them to buy lunch?
Mostly sent the kids with lunches.
And those were made at your home?
Yes.
And you said, I think, that you live close to the school, so would you walk them to school?
Yeah, literally 2 blocks away. The kids, we'd walk during snow, rain, sleet. It's probably only about 4 or 5 days total, as they will tell you, that we didn't walk to school, or I had to drive them because the weather conditions were too bad.
And then at the end of their school, did they start school at the same time?
They did.
Your Honor, I guess this line of questioning may be relevant to a different issue, but I guess the matter here is this order to show cause as to whether or not my client complied with the order. So I guess I think this is a far astray, and I'm not sure the relevance of it in this matter.
Okay, Ms. Elaine, how's it relevant?
Your Honor, I believe Ms. Tabaka essentially denied that Mr. Tabaka even spent much of her working time with the children. So this just goes to her credibility and believability about what the children's status quo is in.
Well, let's focus on the denial. That's the important thing.
All right. Mr. Tabaka, was there any attempt to change the status quo for the children from November to June of 2021?
From November of 2015?
Yes, sorry.
No.
Now, Ms. Tabaka, again, this may be a little bit outside of the realm as well, but for the court's edification, Ms. Tabaka testified that when you did care for the children, you would leave them with girlfriends. Was that accurate testimony?
Again, Your Honor, relevance.
Oh,
Ms. Elaine?
his client testified to that.
Well, quite frankly, I'm going to focus on whether there's a denial or not. I don't care what he did with the children when they were there.
Fair enough, Your Honor. Mr. Tabaka, before this hearing, did you ever hear the term civil co-parenting agreement come out of Alexis's mouth and referring to your custody and parenting time order?
I had never heard the term civil co-parenting out of anybody's mouth.
All right. We admitted as Exhibit A, Ms. Tabaka's timesheets that we procured from the county, correct? And did you have an opportunity to examine those timesheets, Mr. Tabaka?
I did, yes.
And did you prepare essentially a summary of what you assert in this hearing was denied parenting time?
I did.
And I will share my screen and offer this exhibit as proposed E.
Okay, what proposed what, excuse me?
E. Mr. Tabaka, this is a 3-page exhibit. Does this look like the summary that you prepared?
It does.
All right, I would move for the admission of E.
Okay,
Board here, Your Honor.
okay, go ahead, Mr. Schaefer.
Mr. DeBacco, who prepared this document?
I did.
You personally or somebody at your direction?
I produced it.
And when did you produce it?
Oh, boy.
Objection to the word produce. What is,
It's been updated repeatedly, Mr. Schaefer. We've had multiple subpoenas due to how long this is stretched out. So in terms of the date, it's multiple in terms of compiling it.
Okay, when did you compile it?
Well, multiple times. I don't have it right in front of me. We compiled it for the first hearing, for the first hearing date. I compiled it after that. When it got kicked back, compiled it with more subpoena information. It's been an ongoing, it's a living document at this point.
And from what sources did you get information that you put on this 3-page document?
The information came from the timesheets, I can't remember, it's 57 pages, 59 pages that got admitted earlier, the PDF of Alexis's work hours. And that's been done in conjunction with contemporaneous notes.
What notes are you referring to?
Notes that I've taken as all of this has gone on.
Do you have those notes available?
Not in front of me now.
So this is compiled from notes that you kept at some point in time?
This is compiled in comparing the parenting schedule that I have according to the 2015 order in conjunction with the subpoenaed work hours and meshing those two together into a document showing that Alexis is working during time periods where I have parenting time that's been denied by her. My
question is, the notes that you were referring to that has found its way information on this, when were they kept? Where are they now?
Contemporaneous notes?
Yes.
They're kept in files or kept in notebooks.
And where are they at the present time?
In the office.
In the office, whose office?
The office in my house.
Do you have those available today?
I don't have them right here, no.
Your Honor, I'm not sure that a self-proclaimed chart is an exhibit without a foundation on each and every element. We've got him making some assumptions or taking information from a self-kept document that we don't have access to, so I'm not sure it's very meaningful because it's going to have to go through each and every entry to determine the validity or the trustworthiness of that information. So I object to the exhibit as an exhibit because the proper foundation is not laid.
Okay, Ms. Elaine?
Your Honor, this is under Rule 1006 MRE. This is a summary of voluminous writings. First of all, being the 57 pages of timesheets that Ms. Tabaka, from Ms. Tabaka's employment. One option is for us to go through those 57 pages and provide the same information that this 3-page summary does. Obviously, all of the time entries on those 57 pages are not at issue, and we've been able to reduce that to what you see here on these 3 pages. With regard to what Mr. Tabaka has reviewed to add his comments in the far right-hand column, he has testified that he has notebooks that contain that information. He was not asked if those could be produced. He was only asked if he had them in front of him, but it sounds like they exist in the home and could be produced for comparison purposes if this court wishes. Of course, he can testify to this information with or without the exhibit, but it's more helpful to the court as the court reviews the claims here to have this summary in front of it rather than to try to take notes of every line item that Mr. Tabaka could testify to. So I would say the credibility of his notes is up to this court to decide, but he's free to testify orally as the same thing that he could put in this column.
Yeah.
That's part of the problem, Your Honor, is that if he is asking that an exhibit be entered, is not going to be very helpful because apparently some of this information or a lot of this information is based on his self-kept notes that we don't have access to. There's going to be little ability to cross-examine from that. So I don't think we're gaining a whole lot by this chart being an exhibit. If he has a quarrel on a particular day as to his position, then I think he needs to testify to that in order to establish whether or not there was, in fact, a violation of the order.
Okay. Well, what the court will do is the court will admit it as a summary under Michigan Rule of Evidence 1006, subject to, and the court would order that Mr. Tabak would make those notebooks or whatever he has that reflects these dates available and would produce those, make those available to Mr. Schaefer's office.
All right, thank you, Your Honor. Mr. Tabaka, why don't you just give us the overview of how this chart is set up before we start looking at the data on it, please?
Basically what I did is I took days that Alexis was working, cross-hatched those with days that she had the kids, that I had typically had them before that, and then compared the two. So then she also took a large amount of paid time off. So obviously deducted that because if she's not working, then she's not working and she's spending time with the kids in theory. So that time didn't count, and then came up with totals for each day, which is how I came up with the sum of 211.25 hours. And that's through November 3rd of last year.
Right, and that's been a moving target for us, correct? Because as time winds on, the order is still not being complied with.
That is correct. I have an updated database from the last subpoena for covering another 3 months, but again, that still doesn't completely cover it. The only way I can get this information is through subpoenas for her work hours, since that's the only way I can get it.
All right. So taking line 1 as an example, you have the date of 6/18/21, and the hours worked and the paid time off is data you got off her timesheet, correct?
Correct.
And then the makeup time owed you derived from the fact that she did work that number of hours while she had the children and not you, correct?
Connor, I'm going to object. That's a total leading correction. Isn't that correct? It's improper. I mean, he can explain what he did.
Okay, court will sustain the objection. Just ask him how he compiled it and what does it mean. You don't have to suggest the answer.
All right, thank you, Your Honor. All right, so the makeup time owed column, just give us a brief explanation of how you came to the numbers in that column.
Okay, so if I can use an example, I mean, 6/18/21, we'll start out with the first one. Alexis had said that she was off that day and was going to spend time with the children. She didn't. She worked 4 hours. So the makeup time owed, and excuse me, she worked 4 hours. She took 4 hours of paid time off. So the makeup time owed is 4 hours for the 4 hours that she worked. Same thing held true for the next Tuesday, 6/29. On 7/2, she worked the entire day and had the children. So again, the makeup time there is 8 hours. And I basically did that all the way through that entire time period.
And that 6/18/21, that very first line actually corresponds with that first Our Family Wizard, right? Where she said, I'll pop that on, that she was planning, she's off on Friday and planning to keep the kids with her. Right?
That is correct. Yeah.
But she
So gonna keep
wasn't.
the kids until Father's Day, which was that Sunday.
Yeah.
And clearly she worked 4 hours, which, yeah.
All right, and if she noted on her timesheet that she worked remotely, how did you handle that?
According to the court document, which I have been over from the 2015 settlement or court order, I should say. It says when she is working, I can have the children. It doesn't say anything about whether she's working remotely, whether she's working in Alpena. I mean, it's if you're working, you're working. Because if you're working, you're not going to be able to take care of the children during that time. And again, we had 6-year history going that was worked very smoothly.
I'm going to show you an Our Family Wizard message from January 21st, 2022, and ask you first if you recognize this exchange.
First of all, is there an exhibit number on this one, Your Honor?
Yep, it's going to be F.
I do recognize this exchange on OFW, yes.
All right, I move for the omission of F.
Need to find it first, Your Honor. Hang on a second. Did you offer that? I have no objection to that, Your Honor.
Thank you.
Defendant's Exhibit F is admitted.
Mr. Tabaka, it looks like you reached out to Alexis in the morning of January 21st, 2022. Why did you do that?
Objection, Your Honor. Leading question. We don't know if something happened before this or not. We don't know who reached out to whom. It's a leading question.
Okay. Sustained, re-ask the question.
How did this conversation begin?
Began on January 21st. School had just been canceled that morning. We got notice. I don't remember exactly, probably 6:30 or so. They were running pretty late in terms of their notices then. So I went on OFW and I sent her this message. I said, good morning. If you're working today, I'd like to take the kids. As always, when you're working, between Spanish, math, reading, and their Cub Scout adventures, I plan to keep them busy, productive during their school cancellation.
And how did she respond?
She said, good morning. Sorry, Chris. It is unfortunate for the kids that school is canceled. It is my day, however, and I will be keeping the kids. Have a nice day.
And then did her timesheet from 1/21/22 support the fact that she was off that day?
I can't see the top of that heading. She worked 6.5 hours that day. She took 1.5 personal time off. So again, I marked down 6.5 hours for stolen time. Makeup time.
I'm going to show you another Our Family Wizard dated 4/18/22, which I'll offer as Exhibit G. And I would offer that for admission, Mr. Schaefer. I'm sorry, are we waiting on me?
No, I'm waiting on me. I'm
Oh.
looking for that exhibit. I don't find that as an exhibit that you had submitted.
It was an exhibit I submitted. It's message 1 of 1, if that helps.
Okay, all right. I have now located it, Mr. Chair.
All right. All right, and moving for that admission, Mr. Schaefer.
Mr. Lane, could you move that to the left? I know there's a margin there, but where it's cutting off the stuff on the right side. I don't know if you can recenter that or anything.
Let's see.
You just did.
Got it?
Now, if you can move it up so I can read the message.
All right.
Nope, go back. Okay.
I have no objection to G, Your Honor.
Thank you.
Okay. Court will admit the defendant's Exhibit G.
All right, and what was the purpose of this exchange, Chris, or what happened with the 4/18 date?
Could you scroll it up a little bit, please?
I sure can. This way?
The other way. Send to the 22. Trying to figure out who the first message, Natalie, I can't.
Yeah, so this looks like you sent a message
I'm
saying,
going to object to the leading question, Your Honor, and the prompting of the witness.
Your Honor, this is made a little bit more difficult with the Zoom and the zooming in and out of the exhibit. I'm just trying to help him locate.
Well, just ask him the question.
Okay. Can you see that now, Mr. Tabaka?
I see that Alexis wrote at 8:07. Did I write at 8:22?
Yeah, sorry, she wrote you at 8:07.
Okay, so she wrote me saying, "Good morning, Chris. I'm having Maddie to continue to rest till exchange at 11:30. Daniel naturally does not want to go to school, says he's still sick, but has no," I can't read what's over
Fever.
there.
That's okay, just the first part. And then your response.
I said, "Good morning, understand on you taking the morning off work to watch Maddie. We'll meet you at 11:30 a.m. at Denny's. Can let me know what med she's on," and so on. Yeah.
That's good. Did her timesheet confirm that she had taken that morning off for Maddie when Maddie was ill?
On 4/18/22, she worked 8 hours. For makeup time allowed, I put in 3.25 hours for the time period between basically 8 and 11:15.
Because that's when you ultimately got the children, correct?
Correct.
Mr. Tabaka, after you reconstructed your notes with the time cards, you determined that up through 11/3 of 2022, you had missed 211.25 hours of parenting time with the children, correct?
That is correct. There was one mistake, Natalie.
Okay, let's find that and point that out.
On 8/24/21.
Yes.
8/24/21.
21.
Yeah.
21, sorry.
It's okay.
Right here.
I put in 2 hours of makeup time allowed because I misread 12:30 a.m. to 2:30 a.m. I didn't think Alexis could work for the county between those hours, and I misread it. I thought it was 12:30 p.m. to 2:30 p.m. So those 2 hours need to be deducted from the overall database.
All right, fair enough. So you will revise testimonially the 211.25 to 209.25, correct?
Correct, yes.
And how do you,
Excuse me, Your Honor, I'm trying to find that page. I have this chart, a 3-page chart.
Yep.
And I don't have an 8/24/21.
it'll be on the first page, about
Okay.
right in the middle, Tom.
Okay, all right. Okay, located it. Very good.
All right, how do you propose that your time be made up, Mr. Tabaka?
In order to minimize interruptions, I propose that basically the next 14 Sundays, I have the kids for 10 hours per Sunday, for each Sunday. And for the next 14 Fridays, have the kids for 5 hours, basically from after school until 8 p.m. And that'll add up to the total, at least through November 3rd of 22.
Now you have some of that time already, right? You have 1 weekend a month, you have a Sunday, correct?
Yes, 1 weekend a month. I have a Sunday as well as a Friday, so that'd have to be taken into account.
So do I understand you correctly? You're asking for 14 Sundays at 10 hours, which is 140 hours.
14 Sundays that she is scheduled to have, yes.
And then 14 Fridays that she's scheduled to have for 5 hours.
That is correct.
And the math on that is 140 hours for the Sundays and 70 hours for the Fridays, equaling 210, correct?
Correct.
Your Honor, I have no further questions.
Okay, Mr. Schaefer?
Timing wise, Your Honor, as to these notes that that you ordered that be provided, I guess I need to have an opportunity to review those.
Well, and I understand, makes sense. Just
Logistic wise,
what are your thoughts?
if I may ask opposing counsel, how many more witnesses do you have in relation to this hearing?
I will only have rebuttal witnesses if necessary. I'm done presenting witnesses in my case in chief.
Okay. Yeah.
So Mr. Schaefer, I guess I'll go back to you then. You're asking for those notes prior to your cross-examination?
Well, it certainly would be appropriate to have them prior to cross-examination of this particular witness.
Okay. Well, I hate to break these things up, but let me ask you, both of you, do you have time on either this Thursday or Friday? I had a trial that canceled that 2 days, so I have that open.
Unfortunately, I'm leaving town tomorrow for 10 days.
Oh, okay.
Then I'm ready, Your Honor, to go.
Yeah, Mr. Lane, you're not taking any of us with you?
Oh, if you ask really nicely.
Okay. Yeah, I don't know that I can do that. I know Mr. Schaefer can't.
You know, maybe there's a use of the 2 hours we could make, though. I mean, we need, you know, it would be great to be able to keep moving this along. I would just note too, while we're having this conversation, that one of the exhibits I was provided was essentially this exhibit we were just looking at, Mr. Tabaka's analysis of the timesheet, but Alexis's in response. And I wasn't provided any notes that Alexis made in conjunction with her responses. So I guess if that's going to be a requirement for Mr. Tabaka to produce those, the same should be true of Alexis. She needs to produce anything that she made notes or any notes that she used for
Okay.
her explanations.
Mr. Schaefer, do you have any problem with her providing notes if she has those?
Well, if we have them, I don't think there's any problem, but I'm not sure there are any written notes.
Okay, well, we'll leave it up to you to talk to your client about that and provide those if she has those notes. It does seem fair that if we're asking that Mr. Tabaka would again disclose those, exchange those, that she would as well. So the court will order that. Obviously, I understand Mr. Schaefer's point is if he has to have these notes, cross-examination is not going to be very helpful if he doesn't have those. But I really hate to, again, to adjourn this matter again in this case, but I just don't see that there's any option then. In
I
this.
think we have a second day already scheduled on this, do we not?
We do. Can he put his client on and start?
Yeah, I think that would make some sense. I don't quarrel with that. That I think at this point in time would reserve my cross, Mr. Tabaka, and I would start with my client to deal with some of the issues.
Okay, so you're going to reserve on Mr. Tabaka.
Right.
Okay.
Thank you.
Well, thank you. That'll help us. Next time we're in, we won't have to take so long. So, okay, Ms. Tabaka, you're still under oath, and Mr. Schaefer, you can proceed with your client.
Okay, very good. Mr. Tabaka, in relation to this November 3rd, 2015 order, what was your understanding, the reason that these provisions were in there in relation to Mr. Tabaka having time with the children?
They were written in there specifically with regard to the preschool and daycare schedules. That's why they refer to morning time on these days or afternoon time on these days. And so that I could provide scheduling information to the CDC, which they required every week in advance for proper scheduling and billing. That's what that was.
Okay. And was this geared just on the preschool, or was there any discussion with you and Mr. Tabaka at the time this was entered that it would continue on?
There was no discussion of it continuing on. It was basically an alternative to him having to pay for daycare.
Was that an issue at that time?
Yes, it was a huge issue.
Okay, tell us about the huge issue of that.
Your Honor, objection. This is out of the scope of whether there was a violation.
Yeah. Mr. Schaefer, what's your response?
Well, I need to rebut some of this that got in that I don't think was really relevant to this particular matter, but if in fact there was an intent for that being a preschool, this goes to that issue.
Well, I'm giving you a little leeway. She stated that it was not the intent, that the intent was for preschool. No discussion about continuing it, but the court is going to enforce the order as the order reads. And I'm not going to read in anybody's intent in that particular matter. The order is clear, it's clear, and I'm going to enforce it that way.
All right, very good. Did you comply with the literal reading of this order in relation to the parenting time for Mr. Tabaka?
I did.
And were there times, did you have flexibility in your work schedule?
Yes.
And what kind of flexibility did you have?
It depends on the time frame of my 12 years, but there was limited flexibility early on, and now there's complete flexibility to finish my work at any time.
And what do you have specific hours that you work at your job?
If I wanted to put down specific hours, they would be 8 to 4, but I'm allowed to flex that anytime.
And do you flex anytime for the benefit of your children?
I constantly flex for the benefit of my children.
Okay, and the existing order and the asterisk points that were brought out does not give any particular time that Mr. Tabaka may take his children, correct?
Correct.
And if you literally read this, it requires advance notice and being advised of his plans.
Objection leading.
Mr. Schaefer?
I'll restate it, Your Honor.
Okay, thank you.
Does the order state that you must be advised of defendant's plans in advance for him taking the children pursuant to this order?
Yes, it does.
And is there any particular time that the afternoon or the morning is defined hour-wise?
There's no definition.
And we had talked about, or Mr. Tabaka talked about too, that there was some sort of a change from what you were doing to something else. Can you tell us about that?
Sir.
Was there a change in how the two of you got along in parenting your children?
Absolutely. We were just able to get along as best we could for many years and flex, and then in 2021, a deliberate attack against me changed the way we were able to work together quite extensively.
Okay, and I think Mr. Tabaka.
Mr. Schaefer, if I could, I think there's times when you're very clear and I can hear you well. There's times it looks like you're turning away from, and so I can't. So if you could make sure you're turned towards your computer or whatever.
Okay, very good. Thank you, Your Honor.
Thank you.
Mr. Tabaka said there was a change, and he gave a reason for that in relation to an incident with a boyfriend that you had. Is that correct?
Yes.
And that ultimately got resolved in favor of your position, did it not?
Correct.
It was determined there was no cause for that.
Again, leading questions, objection.
Okay, if you could rephrase it, Mr. Schaefer.
What was the result of that complaint?
The result was no preponderance of evidence against Kyle Gallus.
Okay. And from 2015, we heard testimony from Mr. Tabaka that he was an integral part of the children's life right after 2015. Is that accurate?
Again, objection, relevance, that was the objection made when I was down that line of questioning, and that was sustained.
Okay.
Well, I'm not sure that one was sustained, Your Honor. I'm asking what his involvement with the children were early on after the 2015
Well, I'll let you ask it as it relates to the times that he maybe took the children when she was working, as that's relevant. Otherwise, I don't believe it's relevant.
Was there a change in when he took the children in 2015 versus maybe in 2018?
Yes.
And what was that difference?
He was constantly flexing his schedule. I would often have to watch the kids. I would have to take off work so that he could play pinball or do other things. He was not always watching the children. The children were watched by their grandparents quite often. So it was whatever his schedule was. It wasn't him for the kids. It was whatever his schedule was. And then I would have to work around, care for my children.
All right. Now, we were talking about your flexibility at work. Have you worked later in the evening rather than the normal 8 to 5 or 9 to 5? And how often does that take place?
In the last year and a half, it takes place quite often.
All right. And what is the reason for that?
The reason for that is so that I can be with my children during the day, get my work done while they are sleeping, and be in compliance with the provision in the 2015 order.
All right. And during the time, if you're not working and you have 8 hours, when do you put those hours in?
Say that again, please.
If in fact you are logged in for an 8-hour day and you take some time off during the day, when do you make up that time?
You know, in the middle of the night or whenever I don't have my children, I can make up the time.
All right. And does that, that would be times that were not in the afternoon or in the morning that you'd make up that time?
Right, or any time that I don't have the children that would not interfere with following this order.
All right. Now you have seen this chart that your ex-husband provided as an exhibit. Is that correct? The chart of the.
Oh, yes.
All right, and I believe that was exhibit. May I ask the court, which exhibit was his chart?
I think it was Exhibit E.
E, okay, thank you. And did you spend time and go through each of these entries that he had put on this 3-page document?
I do each one individually.
And did you come to the same conclusion or different conclusions that he came to in this matter?
Different conclusions as right here. Clarification on whether advance notice was provided to me for the specific date that he's claiming. I also put in information in there for when the children had prearranged play dates with their grandparents, because that's all facilitated only through me. Oftentimes he would know about these events, but he would still try to interfere using this provision to prevent the children from seeing their grandparents. So I did make note of that.
All right. And are the children involved in extracurricular activities?
They are.
How many different extracurricular activities are they involved in?
They're consistently in piano lessons. Maddie is in violin and she's starting tennis. Daniel does Lego club. And then there's other variables throughout the year, math Olympiad, things like that.
And during these events, when they're children with you, do you get them to these events?
The relevance of this, I would object to.
Schaefer?
I think it's relevant as to whether or not she's working, she's not working, or what, whether or not Mr. Tabaka is entitled to the presence of the children during an afternoon or morning that he's complaining about.
Your Honor, we're not arguing that he should be given makeup time for times that she's parenting the children, only when she put on her time card that she was working.
And that we've addressed some of that. We'll address more of that. Our position is that time card wise, she is in compliance with the order. If there is complaint that the kids are at piano lessons and he's not getting the kids. That's why I'm addressing that. If there's no complaint about that, that's fine.
Okay. Miss Elaine, is that an issue if again the kids are in extracurricular activities that he should have had them or something at that point?
Well, I think the only time traditionally he's had them when she's working are during the school hours and that little bit of time after school until she comes to pick them up. So I don't know what extracurricular activities are occurring in that hour after school.
Okay, well, I don't know, but I'll let Mr. Schaefer go into it. So go ahead. I'll overrule the objection.
And what are the times of their extracurricular activities such as piano?
Piano varies week to week, but Tuesday 1 week, Maddie will have piano at 3. My youngest daughter, it'll be 3:30, and then my son will be 4 o'clock. And I have my mother facilitate picking them up and taking them to those piano lessons because they're busy during that time. So that I can just accomplish a little more work, and then I'm home when they come home.
All right. And so what I hear from you, and correct me if I'm wrong, is that if you're working at their piano lessons, your mother is doing the transportation.
Correct.
Okay. In relation to what was your understanding as to the definition in the order of afternoon and morning?
My understanding to that is specific to the times of the preschool.
Okay. Did it make sense to you that the morning and the afternoon were defined by the preschool times?
Yeah, because that's the way the order was written. That's what it was written for.
Okay. In relation to when you were not following this order, according to your testimony, and you got along with co-parenting, what were times? Were there any specific times that you and Mr. Tabaka agreed that he had the children?
So our standard of what we did for a long time when my job had very specific hours of 8 to 4, I would get the children up and I would drive them to the Denny's and he would pick them up and then he would take them from school to there and then I would go to work. And this was our routine for a long time while we were getting along and there were no issues. And I was fine with that because he had purchased a house near the school and I thought it was the special treat for the kids to be able to walk to school because it wasn't something I was able to do as a kid living in the country. So I always tried to facilitate and allow things that I thought were good for my kids, you know.
Okay. When in 2015, where did Mr. Tabaka live?
He lived in Rives Junction, Michigan.
Okay, over in Jackson County? Say yes?
Yes.
Okay. Now, your exhibit 3 that we have submitted, can you tell us what that is?
Yeah. This is the tabulation sheet that Mr. Tabaka provided to me. I put it all down in a way that it's clear and makes sense to me and added specific notes about that day, where I was, what was going on, appointments, play dates with their grandparents, if I was home with my children, which is, you know, I'm taking care of my kids. I can work 8 hours, of course, a 24-hour day. It's not like a straight 8 hours. So that's what that data is in Exhibit B.
All right. And this is information that you prepared from reviewing his chart?
Correct.
And what did you use to come up with your information in relation to your comments?
I make notes on the side of my time cards, specifically what's going on. If there isn't anything there, I will go into my emails with Mr. and Mrs. Tabaka, the children's grandparents, just to clarify what events were going on, what time, things like that, just to make sure it's completely accurate.
Okay, and you have some of these items that you can make available that we can turn over to the other side to verify what you used?
Yes.
Okay. Your Honor, I would offer Exhibit 3 as a summary exhibit in contrast to Exhibit E.
Okay. Mr. Lane, any response?
May I have order, dear, please?
Okay, Mr. Schaefer, I'm just before we do that, I'm gonna want to see Exhibit 3, and I don't believe I have the paper copy of that, so if you could.
I hand delivered it, Your Honor, myself.
Okay,
That is part on 3-2 of 23.
Okay.
It's connected with the exhibit list. And exhibit 1, 2, and 3 were attached there too.
okay, well, we'll check into that and find out. I don't know if it's, did you do it at the clerk's office or in my office?
Clerk's office.
That's probably why. They don't send us those, Mr. Schaefer, so.
Well, I was assured that they would. It was a
Oh.
time when your office was closed and I
Okay,
hand delivered them there.
I'll pull them up then. I remember as I looked through the register of actions, I did see exhibit disclosure, so we should have those. Okay, go ahead.
All right. I think there's board here.
Yes.
Okay, go ahead, Mr. Lane.
Mr. Bach, I'm looking at what you're proposing as your exhibit 3 on, for example, on, well, let me ask you this. You said that you have notes on the side of your time cards. So we produced your time cards. They don't have any notes on them. So what notes are you talking about on the side of your time cards?
I believe if you do pull up my time cards, the ones that you see that don't have signatures on them, I provide a copy of just the time card. And then I provide a second copy that has tons of notes on the side that would not fit on the standard timesheet. They're usually stapled together and submitted together for reference.
And why are you putting notes on a second time card?
Specifically for these reasons, ma'am, because it's important for me to document it, sadly, every single move I make in my life right now, because my ex tries to use everything against me. So I make notes about everything.
Well, where are those kept?
They're on file with the regular time cards.
So you write your personal notes on your time cards and submit them to the county?
Absolutely.
And how many time cards have no, I mean, I'm just looking at what I've got from the county. I don't see handwritten notes on anything.
I believe that some of the notes that I got from you do have some notes, but I don't think they have all.
Yeah. I mean, as time went on, due to the more aggressive state of his pursuit on this, I started to make my notes longer, more clear, with more information. Originally, it would be dropped off Maddie and Daniel at school at this time and this time. And then it went from that to piano lessons, or my mom's doing the pickup, or Lily has gymnastics, or this is at this time. I've started to put so many notes in there just to make sure that all of the data is recorded for reference for things like this.
Well, I see some typed notes. You said maybe I misunderstood. I thought you said you were handwriting notes in.
No, I put them off to the side of the time card.
All right, I see those. And so besides those notes and emails, what else did you look at to compile your exhibit 3?
Pretty much it's going to be the emails with Mr. and Miss Tabaka. It's going to be text messages with them or my mother or the aunts of my children that also have play dates with the children. Sometimes it is photographs of the specific date of the date that he's claiming time, and I'll see where we are with the children, what we're doing, so that I have multiple points of verification.
And when did you start taking such notes?
I took extensive notes from 2014 when I left Chris originally. And then when the order finally got signed, I took a deep breath and a break from that. I recently started taking notes again when he started this whole cycle of abuse again, because I knew I would have to.
When you say he started the cycle of abuse, do you mean the filing a motion to get back his time?
No, ma'am, I mean a history.
All right. So when was that? You say this caused you to resume taking your notes. I don't know when you think the cycle of abuse began.
Well, there was a clear indication that he was starting to do this when I kept having CPS come to my door.
Can you tell me the year, please? That's what I'm after.
I would say as early as 2020, 2021 for sure.
All right. So for instance, on your exhibit, proposed exhibit 3, you have a note on August 24th of 2021.
Okay. Do they need me to share it?
No.
Okay.
Go ahead.
Sorry, I just said, I found the exhibit. I was wondering if you needed me to share it on the screen.
Oh, I can share mine if that's easier.
Which thing?
So for instance, right here on 8/24/21, you have Alexis worked at office while children were sleeping, Grammy home while children asleep. So how would you have derived that from 2021 for two years ago? That Grammy was.
Your Honor, is this beyond voir dire? I think we're getting into the substance of the matter.
Well,
You know, I think we are going beyond that, Ms. Elaine, to establish the foundation for the mission. So,
well, I guess if I may, Your Honor, my thinking on that is she's saying that she used various documentation to compile this. And I'm testing that out by asking her what documentation, which was going to be my next question, showed that Grammy was home on 8/24/21.
well,
That's cross-examination, Your Honor.
okay, I'll allow just this and then we're going to move on.
Yes, sir. I made those notes the exact night that I went into work, which is what I do with most of my notes. I will go right in. I will make the note of why I'm there that late, what I'm doing, and who's watching my children if I'm there in the same day.
So a note like that would be on your time card, is that what you're saying?
That, well, my mother's watching my children.
Yeah.
And I think that would be a given, probably. I don't know that I would write that specifically.
All
My
right.
mother has, okay.
So that chart that you prepared for this litigation after receiving our chart, at least that particular note, you're just going from memory.
Well, my mother lives at my home right now with these ongoing proceedings, so she's
But
there every
you said it would be. You said it would be a given.
My mother lives at my home right now.
Okay, I'm talking about 2021, August.
Correct.
Your mother lived there then?
My mother has been living with me since the start of this litigation from Chris.
Right, she lives not in your home, but in a trailer behind your home, correct?
It's in an RV, yes, right on my property.
All right, I don't have any further questions, Your Honor. I would just, I guess, again, the notes have to be provided.
Okay. What's your response to the exhibit, Ms. Lane?
You know, I don't have an objection to it being admitted to aid the court and sorting all this out for that purpose only.
Court will admit plaintiff's exhibit 3, there being no objection. But the court will ask that that Mr. Baca would produce those notes, et cetera, that she has.
Okay, very good, Your Honor. Ms. Tabaka, I guess I want to concentrate, if we can, in relation to Exhibit E, which is your ex-husband's rendition, his rendition of what time he is saying that he did not get parenting time pursuant to the order. And I guess there's no way to do this other than going down through each and every one of these entries.
Right.
So let's start on his Exhibit E, entry dated 6/18/21.
Okay.
Can you respond as to, first of all, did you keep the children from him in violation of the order?
Your Honor, I believe that's a legal conclusion. I would object to the formal.
I think both these parties are going to be in that position to determine whether they believe they did or not and what they did or didn't do.
Well, why don't we just confine it to what she did and was she working, et cetera. Court will make a determination if it was a violation.
Okay, on 6/18/21, can you tell us what response you have to your ex-husband's suggestion that you violated the order?
Yes, sir, we remember.
Your Honor,
Excuse me.
yeah, never married.
Yeah.
But okay, so 6/18/21, sir. I had prearranged plans that day with Mr. and Mrs. Tabaka, the children's grandparent, well in advance of this date. And so I took off part of my day to make sure that the children made it to the plans with their grandparents, which I have an email to coincide with that. And then while my children were engaged in these plans with their grandparents, I fulfilled some of my job responsibilities for 4 hours instead of getting my nails done for 4 hours. Because
On that particular date, did you get a advance request and a determination of what the plans were from Mr. Tabaka?
so what I got from Mr. Tabak is that he was going to work on that date. And that's when he asked if he could get them early to take them with him to work.
And where was he working on that day pursuant to his indication to you?
John Balzu.
Okay, and as a result, were the kids out of school at this point in time? In June?
Yes,
Okay, and they were with their grandparents on a arranged outing with them, is that correct?
correct.
How about June 29/21?
All right, June 29. He's just claiming Daniel on this for 4 hours. I was home with Daniel. Maddie was at Camp Henry. And I worked remotely. I was home with my son all day, and over the period of the day, I put in about 4 hours, but I was with my son all day.
Okay, and so, and the order is the mornings with the son, is that correct?
Defendant may take children for afternoon parenting time and the younger minor child for morning parenting time. Right.
All right. Okay, and the next date that is there is 7/2/21.
7/2/21, the weekend of the 4th of July. Again, traditional prearranged plans with paternal grandparents, Mr. and Miss Tabaka, something that we do yearly. Daniel had some one-on-one time with them prior to me picking Maddie up from Camp Henry.
Your Honor, if I may, I would object to especially what's going to be incredibly lengthy testimony about prearranged plans as irrelevant. I mean, either she was working and the time should have been offered to Mr. Tabaka or not. I don't know that it matters what she did with the children when she was working, when she didn't.
I guess I disagree with that, Your Honor. I think certainly extracurricular activities and pre-planned with grandparents, and whether or not there was advance notice and plans given by Mr. Tabaka are all relevant pursuant to the order, especially when we have an order that doesn't even give any times. It's a morning, it's an afternoon, whatever that might mean.
Well, maybe we could confine it to those, to the order stating after either afternoon or morning, or if in fact she's working. Quite frankly, I agree with Miss Elaine. If she had pre-approved plans, I don't care who they were with. If she was working, then that seems to be that would kick into place those provisions.
Okay, I guess we were on 7/2/21. Did you work that day?
Yes,
And did you get request from Mr. DeBaca in relation to the children?
Your Honor, we
I
will,
have no advance notice or
Oh, okay,
specific.
just a
Hold
second.
on.
I think there's an objection.
we will stipulate to save an inordinate amount of time that Mr. Tabaka was not on a daily basis saying, I want to exercise time with the kids tomorrow and saying his plans. I think whether he had to say the plans with the children is a legal question. But I mean, if he's going to ask about every single date, whether Mr. Tabaka said the night before, starting in 2021, that he wanted to exercise time with the kids, the answer is he did not. But I think it's up to this court to determine whether a violation still occurred.
Well, okay, I guess I truly believe that is a linchpin of the order. There are certain requirements, including that. And if the opposing counsel stipulates that he did not on any of these days make a request for that specific day, then that would be helpful.
Okay.
Well, yeah, it doesn't say he has to do it every day. The order just says that he has to do it, and he did it when they made this agreement and they started exercising it. It wasn't ever a requirement that he had to do it on a daily basis. And she,
Okay, excuse me.
Okay, so you're saying, Ms. Elaine, that you acknowledge that, again, for purposes of this hearing, that he didn't give advance notice on each and every one of those days, but just a generalized statement.
he gave, yes, at the beginning, and that's where they operated under that general statement and general plan for years. And then once she started withholding, he did send her messages that through our family wizard that he wanted to continue that, which she rejected.
Okay.
I guess I don't want to be short-armed on this one. If in fact I can rely on the fact there was no advance notice given on these particular days or for these particular days, then I will accept that. Otherwise, I'm going to go through each one of these.
And again, I'm not saying there was no notice provided by him. There was. It just wasn't on a daily basis, and I don't believe the order requires that.
Okay, so at least in regard, just to clarify, Ms. Elaine, that he did send some messages through our family wizard. And so those would obviously be notice of his, advance notice. But as to the other dates, you state that there was no advance notice other than generalized.
Right. There was general notice at the beginning that he would exercise all the time that she worked, and that's what they did. And it was only when she stopped doing that that he started saying on our family wizard, I want to continue doing what we've been doing for the 6 years that we were doing it.
Okay. Mr. Schaefer, does that give you any direction in this matter?
I'm not sure. It depends on what your honor is going to receive, because there was not advance notice given on, I think, each and every one of those. If that's what she's saying, fine. If it's not, I'll go through each one to do it.
No, I think she's saying there's generalized, and the court could, again, go with the standpoint when he sends a note through our family wizard and says, I want to take the kids, that at least it would pertain to the next time she works, if that's the Friday or whatever this, applies to. Mr. Schaefer, I can't hear you at all.
I guess I'm not sure the rule. I think I'll go through each one of them.
What was that again?
I think I'll go through each one of them because I hear a weasel word at the end of it, but there came a time when he did make certain requests.
Okay, go ahead then, Mr. Schaefer. We try to, again, make this a little easier, but apparently we're not going to. So go ahead.
I believe we were on 7/2/21. Did you work that day?
Yes.
Did you get advance request for parenting time that day? Did you get an advanced statement of what his plans were for the children on that day? And was there time during that day that you were with your children?
Yes.
And were you on flexible time when you worked other than the 8 to 5 time period?
Yes.
On 7/7/21, did you get advanced notice for any time with the children from Mr. Tabaka? Did you get any advanced statement?
Hold on, Mr. Schaefer. I'm hearing your questions. I'm not hearing her answers at all.
I'm sorry. Okay. The last question was, I believe on 7/7/21, did you get any advanced notice from Mr. Tabaka?
Right, and I heard no answer.
Okay,
I did not.
Okay, speak up, ma'am.
Sorry, sir. I did not get any advance notice nor any specific plans about 7/7/2021.
I could hear that. That's good.
Your Honor,
Thanks.
could we have a ruling potentially, again, just trying to make it so this hearing isn't 7 days long? Could we get a ruling from the court as to whether the language that so long as plaintiff is advised of defendant's plans in advance means that he has to tell Alexis what he's doing with the children on that day, or whether that means he has to say that he wants the time?
Okay, Mr. Schaefer, do you have any input?
certainly, the language is poorly written. Since I wasn't the attorney of record and neither was opposing counsel, we can say that. It's poorly written from the standpoint that we don't have any times on afternoons or morning, but the literal reading of that is that I would think that it would mean I want to see the kids tomorrow and we're going to go to the park.
Okay,
Or we're going to go to a movie, or we're going to do something. But that is certainly a requirement in the language that I think both parties were obligated to follow and rely on.
okay. Well, court will, based upon the request, the court will make a ruling on that. And as I read that, it is obviously a disjunctive sentence, and it states that during such time as plaintiff is working, so long as plaintiff is advised of defendant's plans in advance. I'm not going to interpret that as he has to advise her, okay, we're going to go to Lake Michigan, or we're going to go here, or we're going to go there. Simply, it pertains to during such time as plaintiff is working, and so long as plaintiff is advised of his plans in advance. I would interpret that as his plans in advance to take the children.
Thank you, Your Honor.
Objection noted for the record, Your Honor, please.
Yeah, that's fine. Court will note your objection.
Okay, very good. All right, on I guess we're on 7/7. I think that's where we're at of 21. Were you working on that day?
I was working from home with the children.
And did the defendant make a request?
There was no request from the defendant in advance as to taking the kids or plans or anything.
Okay. On 7/13/21, what was the situation there?
I worked 4 hours. I was home working with the children remotely throughout the day, and the defendant did not give advance notice of his plans.
On 7/16, what was the situation?
I worked 4 hours from home with the children remotely throughout the day, and defendant did not give advance notice of his plan for that day.
On 7/21, what was the situation?
So it's going to be 4 hours. I worked remotely from home throughout the day, out of town with the children, and the defendant did not give advance notice of his plans for that day.
On 7/23, what was the situation?
The defendant claimed 2 hours. I was working from home with the children remotely 4 hours throughout the day, and the defendant did not give advance notice of his plans for that day.
On 7/27, what was the situation?
He's claiming 4 hours. I was working from home with the children remotely 4 hours throughout the day. And the defendant did not give advance notice nor specific plans.
On 7/30/21, what was the situation?
A defendant's claiming 4 hours. I was home with my children. And I worked remotely 4 hours throughout the day, and the defendant did not give advance notice of his plans.
Here, let me, a little more detail, like on 7/30, was this a time the kids were in school or not in school?
Not in school.
This is in the summertime.
Correct.
Okay. On 8/2/21, what's the situation?
Defendant's claiming 8 hours. On that date, I had prearranged, it was our pre-agreed vacation week, plans with the children. And I had planned with the paternal grandparents from 8/2 to 8/4 in Holland, Michigan, of which I worked remotely when I was there. And the defendant gives acknowledgement of the week-long vacation through OFW, but did not give advance notice in our specific plans for wanting to take the children from my vacation.
All right, so you and Mr. Tabaka had agreed that on 8/2 that would be your vacation day?
Yeah, there was a whole week of vacation and he got a whole week of vacation.
Okay, but he is claiming 8 hours makeup on that?
Yes,
And that's during a time that you and he had agreed to take a week's vacation.
correct.
On 8/3/20, August 3/21.
Claiming 8 hours again, continuation of the prearranged, pre-agreed vacation. The children were with me and their grandparents in Holland and South Haven, and the defendant did not get advance notice of his plans.
On 8/4/21.
Continuation of the prearranged, pre-agreed vacation. He's trying to claim 4 hours. Again, we were in Holland and South Haven with the grandparents of the children. I worked remotely from poolside. The defendant did not give advance notice to his plans.
On 8/5/21.
He's claiming 4 hours, and this is more of the prearranged, pre-agreed vacation. Again, I was out of town with my family working remotely. The defendant did not give advance notice of his plans.
On 8/6/21.
Claiming 4 hours. This is again, prearranged, pre-agreed vacation with me and the children out of town, and I worked remotely, and he did not give advance notice of his plans.
And which week did he get that you had agreed to? Do you recall that?
It was either the week before or the week after.
Okay, and there's an email that
Yeah,
that verifies that.
yep, and it's in the OFW calendar.
Okay, and then we're down to August 24th. He's claiming 2 hours. So what happened on August 24th?
So that's the one where I was working from 12:30 to 2:30 in the morning while the children were sleeping at home with their grandmother, and he did not give advance notice of his plans.
Your Honor, that was the date Mr. Tabaka corrected for the record that subtracted those 2 hours off.
Okay. 9/3/21. What was the situation there?
9/3 is claiming 7 hours. The children had no school. Children had scheduled activities with paternal grandparents all day, and I drove the children to their grandparents in Holland and Michigan, and I worked after 5 p.m. for a few hours, and defendant did not give notice of his plans.
Okay, and how many hours after 5 p.m. did you work on that particular day, as you recall?
Well, I have seven hours written down.
7 hours and that was in the evening?
Yeah,
I would object to facts not in evidence if how she's testifying that she worked 7 hours after 5 o'clock.
That's cross-examination, Your Honor. It is evidence.
I'll overrule the objection. She can testify as to what she worked.
So on 9/3, you worked 7 hours, and that was after 5 o'clock. Is that correct?
correct.
Okay. Was that an unusual situation, or did you have a number of times that you would work late in the evening?
Oh, yeah, that's not unusual anymore.
Okay. Well, is it unusual in 2021?
It was becoming more common.
Okay. We're to 11/5/21. Again, what's the situation on?
He's claiming 8 hours, and I was home with the children. Our entire household was under COVID quarantine, and I worked remotely throughout the day. Chris had also tested positive for COVID. That's in an email on OFW, and he did not advise of his plans.
Okay, well, did he make any request to have the children on the time that they were suffering from COVID?
No, I have no email of advanced plans or taking the kids.
And they were quarantined at home, is that correct?
Yes,
And 1119 is the next one.
he's claiming 8 hours, and the household is still under COVID quarantine because another one of us tested positive. And I worked remotely at home with the children. He did not give notice of his plans.
On 1130,
I don't have 11:30.
I guess he's claiming 0 on 1130.
Okay.
1222 of 21.
He's claiming 7.5 hours. The children were on winter break, and the children spent the day, they had plans with my mother. And so while they were with my mother, I worked at the office. He did not give advance notice of any plans.
1228 of 21.
That's 12:27.
It should be. I'm looking at his, it says 1228.
Okay. So we did talk about 12:27 or skip to 12:28.
Okay, let's go to 1227. I don't see that on his chart.
I have that he's trying to claim 1 hour. And I've got maternal grandmother watch the children for 1 hour before driving them to their 11:30 drop off in Marshall, which is a 30-minute commute one way. Because my mother doesn't take the highway, and there were no specific plans provided on that date.
No request for the children on that date.
Correct.
1228 of 21.
He's claiming 8 hours. The children are on winter break. I did work at the office, and the children spent the day with both their maternal and their paternal grandparents with prearranged events. And the defendant did not provide any plans in advance of anything.
On 111 of 22. Like I said, that's a 0 makeup time. All right, so 121 of 22.
121, he's claiming 6.5 hours. School was canceled due to weather conditions. I worked at the office for 6.5 hours. The children spent the day with their maternal grandmother. There was no reason to have the children on the roads with the weather and to do 2 round trips on the roads, but the defendant did not give advance notice of his plans anyway.
Was there any conversation that he wanted to see him on that day, even though there was a closed school?
There was an email in OFW at 10 to 7 about getting the children. And without having the email in front of me, I'm sure that I did reference that the schools are closed because the roads. And so to travel to Marshall, and again, I do all of the driving, to travel to Marshall on dangerous roads, 2 round trips was not necessary for the children.
Okay, and 22 of 22.
22 of 22, he's claiming 8 hours. School was canceled due to weather conditions, and I was home with the children all day working remotely. Defendant did not give advance notice of his plans.
On 24 of 22.
24 is claiming 6 hours. School was canceled due to weather conditions, and I was home with the children all day working remotely. He did not give advance notice of any plans.
On 218.
Claiming 6 hours. School was canceled due to weather conditions. I worked from home with the children remotely 6 hours throughout the day. And then it's like we had evening plans with the paternal grandparents. Defendant didn't give notice of any plans.
I get the 30th of March, 22.
He's claiming 4.5 hours, and this is Alexis's prearranged, pre-scheduled spring break with children began on this date at noon. He had them the first half, and noon was the exchange time. And I picked up the kids at noon in Marshall, and then I returned and I went for 4.5 hours while my mother watched the kids and brought them to their piano lessons, which were the same day. He did not give me notice of any plans.
So this was your prearranged spring break time?
Correct.
He was aware of that?
Yes, It's on the OFW calendar.
All right. 3:31 of 22.
77.25 hours. This is my prearranged, pre-scheduled spring break with the children. I worked in the office early in the morning and then took the children to their counseling appointments at noon and 1. And then the children spent some time in the afternoon with their maternal grandmother, and I returned and worked in the office for a couple more hours. He did not give me any notice of his plans.
And again, that was your spring break time that you and he had agreed to.
Correct.
4/1 of 22.
4/1 of 22, prearranged, pre-scheduled spring break with the children. Defendant did not give any notice of his plans.
Okay, and 4/15 of 22.
Claiming 5.5 hours. It was Good Friday. Children had no school. I had prearranged traditional Easter plans with the paternal grandparents, so we went to Holland. And I worked while the children were doing their Easter stuff with their grandparents. He did not give me any notice of his plans.
Was this part of the spring break?
That might have been the conclusion, Good Friday, but I'm not sure.
Okay. 4/18 of 22.
He's claiming 3.25 hours for just Maddie. I worked remotely in the morning to include taking jabber calls on my phone while commuting my son to school. Maddie remained at home because she wasn't feeling well and was sick, and rested until it was her time to be transported to Chris at 11:30. And then I went into the office after Maddie was dropped off to Chris at 11:30. He did not give any notice any plans.
But he did see the child at 11 o'clock at that time?
The normal court-ordered scheduled exchange time of 11:30. Yes.
Okay. On 5/11 of 22.
He's claiming 3.75 hours. Children had a half a day of school. I worked from 9:30 a.m. to 3:30 p.m. and my mother picked the children up from school and took them to all of their piano lessons, which concluded at 4:30. Defendant did not give advance notice of his plans.
And what time were the piano lessons?
They are at 3:30 and 4, and they're half an hour in length each.
Yeah. And where are the piano lessons? Where do they take place at?
They take place at the East End Gallery basement.
All right, in Marshall.
Marshall. Yeah.
Mr. Schaefer, what was the date of that? I missed the date.
That was 5/11 of 22, correct?
Okay.
Yeah.
Okay, thank you.
5/31 of 22.
Claiming 2.25 hours. Children were released from school at 3:40 and picked up by maternal grandmother who took the children to dinner and shopping until Alexis left work at 6. I worked remotely from the ball field where Daniel had baseball from 6:30 to 8:15, and the defendant did not give any notice of his plan.
On 6/3 of 22.
He's claiming 4.25 hours. It's the last day of school, a half a day. My mother picked the children up from school and took the children shopping for a birthday present for their friend O'Hara, whom they had a sleepover later that evening. Alexis came home from work at 4 p.m. and spent time with the children until she transported them to the birthday party sleepover. And Alexis returned to the office later that night while the children were away, and the defendant did not give notice of his plans.
6/3 of 22.
I've got, that was 6/3.
Oh, that was 6/3. I'm sorry, 6/13 of 22.
I've got 6/17.
Okay, okay, I guess there's nothing for 6/13, there's nothing for 6/15. 6/17, I guess a half hour he's requesting. What happened on the 6/17?
6/17, claiming a half an hour. I worked from 5:30 a.m. to 9:30 a.m. And I took Daniel to his sleep study appointment at 1. OFW email from defendant, intention of exercising his parenting time but failed to communicate any plans. He's trying to claim the 30 minutes from like 9 to 9:30, even though it takes more than 30 minutes to do a commute drive to Marshall.
6/24 of 22. I guess that's a 0 time. And then the next one he has time is 7/1 of 22.
7/1 of 22, he's claiming 6 hours. Children had prearranged theater arts plans with the paternal grandparents in Holland. And I worked at the office while the children were with their paternal grandparents. There is an OFW email from the defendant at 7:20 advising of the intention of exercising parenting time, but failed to communicate any plans of the execution thereof. And he also acknowledges that his own parents tried to communicate with him regarding these plans, but he would not respond to them. So he was aware of these plans with the grandparents.
And is this a common extracurricular activity that the kids have with the grandparents in the theater?
Yes, it is. Yes, it is.
And 7/7 of 22, that's a nothing. I guess we're down to 7/11 of 22.
7-Eleven, again, claiming 1/2 an hour, defendant's asking for half an hour in the morning in which the plaintiff gets the children till 11:30. And it's basically that commute time that he's asking for, that 30 minutes. He did not provide any advance notice of any plans.
7/13 is a 0. I guess we're on to the next page of 7/18 of 22.
7/18 of 22 is claiming 1 hour. Defendant is asking 1 hour. I worked early in the morning while the children were sleeping. Defendant is trying to claim the hour between 9 a.m. and 10 a.m. He did not give any notice of his plans.
And again, there's a half-hour commute. Is that correct?
Yeah.
Okay. 7:20, I guess there's nothing there. We're down to 9/6 of 22.
9/6, he's claiming 2 hours. I work from 8 a.m. to 5 p.m. All 3 children have piano lessons from 3 to 4 p.m. My mother picked the kids up from school and took them to piano, and I arrived home approximately the same time the children get home from school. The defendant did not give notice of his plans.
On 9/20 of 22.
Claiming 2 hours again. Alexis worked 9 a.m. to 5 p.m. All 3 children have piano lessons from 3 to 4:30, which my mother takes them to those piano lessons, and then I get home the same time they do. And he did not provide advance notice of his plans.
On 10/12 of 22.
10/12 of 22, he's claiming 3 hours. It's my parenting day in which I had pre-arranged play date plans with Aunt Denise and Aunt Debbie, the children's aunts. I worked till the play date was over at 2:30 p.m. And then I took the kids to their piano lessons in Marshall. The defendant emailed on 10/11/12 advising about taking the kids if I'm working. Defendant did not provide any plans in his email. Defendant was sent a reply within 20 minutes indicating that I had already made plans for the children that afternoon and that these plans were also noted. They're on my time card and in OFW. So he knew that there were plans for the children.
And there was no advance notice of this request?
No, he did on the 11th. And at that time, I told him that there were already plans in advance for the children to be with their aunts.
Good. And 10/18 of 22.
He's claiming 2 hours. I work 8 to 5. All 3 children have piano lessons from 3 to 4:30. My mother picks the kids up and takes them to those piano lessons, and I arrive home at the same time they do. Defendant did not give advance notice of any plans.
10/28 of 22.
He's claiming 3 hours. The kids had a half a day, prearranged play date plans with Aunt Debbie and fellow student to decorate Halloween cookies from noon to 2. Alexis received the kids from Aunt Debbie at 2:40 and then sent Maddie up for her drop-up class from 3 to 4. And the defendant did not provide any notice of his plans.
11/1 of 22.
Claiming 2 hours, 8 a.m. dental appointments for Maddie and Daniel. Then I worked from 9 to 5. All 3 children had piano lessons from 3 to 4:30. My mother takes care of that. And then we arrive home at the exact same time. Defendant did not provide any plans for that date.
And how long when were the dental appointments for the kids?
It's 8 a.m. So from 8 to 9, and then they go straight to school.
Okay, 8, 9 straight to school.
Mhm.
All right, and so what 2 hours do you think he is talking about here?
The time where my mother is picking them up and taking them to their piano lessons. That
What time did they get out of school?
Daniel gets out at 3:40. Maddie gets out at 2:30 approximately. She goes first, then my youngest child, and then Dan. They're all back to back.
They're all back to back.
Yeah, and they're all facilitated through me. They are piano lessons that I arrange.
Okay, so there really would be no time for Eden to be with them if you take into the commute time. Or
I'm sorry, I can't hear Mr.
Yeah,
Schaefer.
Mr. Schaefer, we can't hear you.
All right. So is there any time available for parenting time if you take into the commute time of the kids from school to their piano lessons?
No.
Okay. Then the last one, I believe, is 11/3 of 22.
He's claiming a half an hour. That day I had a work training and seminar, and so my mother brought the children to school. And I'm unsure as to where the defendant's trying to claim a half an hour of denied parenting time, other than that 30-minute commute from the house to school. Because I had to clock in at 8, and then Daniel's school starts at 8:30. So it's literally taking that 30-minute commute time, this parenting time.
Good.
And there's no advance notice of plans for that date.
Okay. You have you had discussion with Mr. Tabaka about the meaning of this time that the order gave him in the morning and afternoons?
I probably none. We are not really. There's not a healthy enough relationship for communication with this individual right now.
Do you believe that you have followed the order?
I do.
Have you made an effort to follow the order?
Yeah, absolutely.
And have you made the children available to Mr. Tabaka based on the order that was in the best interest of the children?
I believe so, yes.
And Your Honor, I guess I will probably have more questions for my client after cross-examination, and probably after cross-examination of Mr. Tabaka. It may be a good time to maybe break and each side provide the notes available, and we continue on. I think we saved an hour here of evidence time.
Okay, Ms. Elaine? You're muted or something. I can't hear you.
Sorry, I don't have an issue with that. I would just ask Mr. Schaefer, can you give me a more legible copy of Exhibit 3? It's very, very blurry.
I will attempt to do so.
All right.
Okay, well, why don't we, with that in mind, why don't we again recess at this point? We'll adjourn and we'll be in touch with your offices tomorrow as to the next date.
Well, we already have a next date on April 19th.
Oh, April 19th?
Yes.
Okay,
That's
good. Okay. Good.
Okay,
We'll see you back then at that time, and hopefully we can get the matter completed.
Okay, great.
Thank you.
Thank you.
This hearing continued in this matter for several days for the next while, which unfortunately I don't have video of, but according to the docket notes, Mrs. Tabaka, along with Attorney Schaefer, and Mr. Tabaka, who was the defendant, and Attorney Elaine, all appeared via Zoom at the following hearings. Testimony was taken, the hearing was concluded, the attorneys gave their closing arguments, and this matter stemmed from a motion to show cause and make up parenting time filed back in July of 2022. Now, this hearing is taking place in March of 2023. So we're already going on, 9 months? The court gives the following ruling. Plaintiff, which is Mrs. Tabaka, is found in contempt of court. Defendant is awarded 39.5 hours of make-up parenting time to be taken over a period of 6 months that starts today, which was May 12th, 2023. Defendant can take these hours on Fridays for 5 hours or Sundays for 10 hours. The parenting time provision in the original order regarding custody, parenting time, and child support is from November of 2015 that deals with the petitioner, which is Mrs. Tabaka, is modified in the following way. Mrs. Tabaka must notify Mr. Tabaka 48 hours in advance of when she works in the office and not have the children in her care. Mr. Tabaka must notify Mrs. Tabaka at least 24 hours in advance of his intent to take the children. If Mrs. Tabaka fails to notify Mr., he will be entitled to have the children. If Mr. fails to notify Mrs., he forfeits the right to take the children for that particular time. The court grants half of the attorney's fees in this matter to Mr., subject to the taxing on the part of Attorney Elaine. Attorney Elaine has 30 days to submit the bill. Attorney Schaefer will then have 30 days to file an objection. Mrs. Tabaka will have 90 days to pay the fees once the final amount is determined, and Mr. is required to notify Mrs. 7 days in advance of the time when he will exercise the make-up parenting time. Immediately after this, a child support order was entered with the standard calculations, but Dad contested it. They fought over attorney's fees, bank records were subpoenaed, Mom's boyfriend was subpoenaed, gym records, PayPal records, depositions, day trading records, Grandma was deposed, evidentiary hearings with the referee, and then finally in September of 2023, a motion for compliance by Mom went to a hearing in front of Judge Kirkham. This brings us to our current hearing, which is September 11th of 2023. Yes. Quite the shit show.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2015-1447 Alexis Tabaka versus Christopher Tabaka. Today is Monday, September 11th, 2023 at 9:29 a.m.
Good morning to everyone.
Good morning.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. This matter is before the court on the plaintiff's notice for entry of order following hearing. Ms. Elaine has objected, Mr. Schaefer, stating that both of your orders are wrong, and why don't you respond?
Okay, and that's the reason I've noticed both of these up, Your Honor. As you noticed, there are two orders stemming from March of 23 and May of 23. We have been unable to come to accord on the language. So they need to be entered to effectuate a lot of things, including the amount of support that has been not complied with without any order being in effect. I believe that they are accurate based on Your Honor's rulings, and the one in relation to Your Honor's rulings after it had been objected to the first time. So I'm submitting to you that I think they're accurate from your rulings, and I'm asking that to be entered.
Okay. Now, Ms. Elaine does state that, again, because the court had referenced in the finding in this matter that it would, and I use that by analogy, it shouldn't apply in instances where it was, let's say, going to be less than an hour because of the transportation issue. So now she states that we could, I guess she doesn't have an objection if we state that it would not be applicable, or he couldn't have that period of time if it was less than an hour in the morning, but in the afternoon, where again, she may be working and it'd be more than an hour, you would put in there that simply that it would be limited, you know, to the transportation of the children, but court didn't order that it was limited to transportation, that again, that it was during the times that she was working. So why would that not be appropriate to just state that, you know, he has a right to have the children at times she's working, except if it's a period of, let's say, an hour or less?
I think that would probably be consistent with Your Honor's ruling, along with the other language that I had in my order. I would have no objection to placing it in.
Okay, Ms. Elaine, then that apparently addresses your objection. Is that correct?
Well, I'm a little unclear on what opposing counsel just said. He said, as long as my other language is included. So as I suggested, I believe that his paragraph should be stricken and just that one sentence it should be replaced with.
Okay, then the court would in fact order and to clarify that again in the morning that it's that the parenting time would be if in fact the children would not be available for more than an hour, that he wouldn't have that particular parenting time.
Less than an hour.
Excuse me?
Less than an hour.
Yes.
Yes.
If it's an hour or less.
Yes.
That he wouldn't have that parenting time, but
Right.
otherwise he would have the parenting time at times that she's working. If it's over that hour, and the court, additionally, there was the issue concerning the child support, the court would allow the deductions as, I guess you say, is calculated by the referee. So I'm not going to open it up to any other deductions. I think those are appropriate.
Right, Your Honor, and I don't think we're arguing that, at least I'm not arguing that whatever the referee did with Ms. Tabaka's income should be changed. No one objected to that, and no one, there was no ruling to the contrary. But I think I did find, in going through opposing counsel's calculations and comparing just the Alexis Tabaka column with the referee's column, I do think I found the error in opposing counsel's, which resulted in that, whatever it was, $12 difference. And I can show you if you'd like.
No, I saw your pleadings. All I'm saying is that the referee's deductions were appropriate and the
Right.
court will utilize those.
Right, but I think we're both utilizing them, but still coming out with different numbers. But it's because opposing counsel is starting out with the wrong base income for Alexis. I can show you really quick if you want.
Well, go ahead and mention what it is, Ms. Elaine.
All right, thank you, Your Honor. If I could just have my screen share enabled, I have it all up and highlighted for you.
Okay.
It's still disabled, Your Honor.
Let's see, hold on, just a second.
Other income from your job other than
Oh.
hourly wage. You get it's
What
like 50 and
participant? You should
300.
be able to share.
Okay, it says host disabled participant screen sharing.
One participant can share at a time. So you should be able to share.
Still blocking me.
Oh, all participants. Here we go.
Ms.
Okay,
Elaine, you sure Mr. Schaefer doesn't have control of that screen share?
I'm not sure of that at all. Let me do this here. Okay. Step one. All right. And okay, on the left-hand side is Mr. Schaefer's. And if you can see here, he starts out with a total monthly gross income of $41,9507 for Ms. Tabaka. On the right is the referees, and he starts out with a total monthly gross income of $45,1024. And you can see at the end, after all the deductions and such are taken, which I believe both of us inputted correctly, and the same as the referee, Mr. Schaefer's ending up with $26.39 for her net, and the referee ended up with $26.69, and that makes that $12 difference in the end. So what I used are the numbers the referee used, and Mr.
Okay.
Schaefer did not.
Mr. Schaefer,
Well,
what's the discrepancy?
I don't necessarily agree with her analysis of what was used or not used. I think Your Honor ruled that it was the numbers that the referee determined for your order. I will go back and check it. I'm not sure that screenshot convinces me any more than what we had talked about before, but I will
Okay,
recheck.
well, what happened is the court had previously stated the court was going to use the referee's numbers, so I used the referee's numbers. I don't know what the discrepancy is or how it is. I'm just using the referee's numbers, so use the referee's numbers, and that will give us the correct amount then.
Your
Okay,
Honor, will
very
you
good.
please enter the uniform child support order that I attached that uses the referee's numbers, because Mr. Schaefer's does not.
Okay,
I disagree, Your Honor.
Your Honor, one of the issues I have and why it's a little irritating that we're here today is that I asked Mr. Schaefer specifically to show me his discrepancy, my discrepancy, show me where I was wrong, and he just never responded. So
In all
even
due
as we sit
respect,
here today, I don't know what he claims the right number should be vis-a-vis
we
what the
have-
referee did.
I've responded numerous times. The response is not what she wants to hear. And so that's why I noticed it up.
That's not
Okay.
true.
well, the court the court will, again, it does look like there's some difference, but I don't know what is causing the discrepancy, but the court has stated we'll use the referee's numbers. So if we're using the referee's numbers, we should end up with the referee's amount. And if that's included, I will give you time to Mr. Schaefer to review Miss Elaine's numbers. Miss Elaine, if you would just renotice your UCSO up under 7-day. And unless Mr. Schaefer comes up with something substantial or showing how again, it doesn't comply with the referees, my intent would be to order it and enter it at that time.
I did show him all of that back in June.
I understand, but he's noticing up his order, and we'll notice up yours as well, so that we get them at the same time, and we'll get them entered. So thank you. Court will conclude this matter at 9:39 a.m. You're free to go. Have a good day.
Thank you.
Thank you.